Good morning. Today we'll be hearing from two panel sessions comprising representatives of the Department of Justice and Community Safety, Josh Smith and Andrea Davidson. Welcome. And later in the day, Ryan Phillips and Larissa Strong. This is the fifth day of the hearings in Hearing Block 5, where we are primarily hearing from the government witnesses on the priority areas of child protection and criminal justice. Before we start today's hearings, I would like to invite Commissioner Hunter to give a welcome to country and acknowledgement of country.
Thank you, Chair. I'd like to acknowledge that we are on my ancestral lands, the lands of the Wurundjeri, and pay respects to my elders, past and present. Also acknowledge those that have worked tirelessly to get us to this place where we are today so our voices can be heard. We'd also like to acknowledge, particularly today, our youth that are lost in systems that aren't built for them, that are separated from their family, kin and culture. I'd also like to, just going a little bit off script, is those that are listening or those in the room that have been all week, to check our socials. 1300 Yarn is probably where I'd direct people, but the social and emotional wellbeing of our mob is highly important during these hearings. And for those that are streaming every day online, I encourage you to reach out, to really look after yourselves. So, Woman Jekka, come with purpose, and thank you, Chair.
Thank you for that, Commissioner Hunter. May we have appearances, please, Counsel?
Thank you, Chair. My name is McAvoy. I'm Co-Senior Counsel assisting the Commission, and I too acknowledge that we are here today on Wurundjeri country, and I acknowledge Wurundjeri people's ancestors and spirits. Thank you.
Thank you, Chair. I appear for the State of Victoria with Ms Louisa Frederico for the first set of witnesses on the first panel, and with Ms Siobhan Kelly for the second set of witnesses on the second panel. I'd also like to acknowledge the traditional owners of the land we gather on, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past and present, and also pay my respects to all of the Aboriginal people who are here today.
Thank you.
Thank you, Chair. I should also record that I'm assisted today by Junior Counsel Mr Nick Boyd-Kane. Thank you.
Okay.
Commissioners, today we have two witnesses on the morning panel, Mr Joshua Smith and Andrea Davidson, in relation to youth justice, and then we will have another panel this afternoon in relation to correctional services. The witnesses are presently in the witness box, and I propose to swear them in and commence evidence.
Okay.
Thank you. Starting with you first, Mr Smith, could you just say your full name and position, please?
Joshua Smith, Deputy Secretary of Youth Justice for the Department of Justice and Community Safety.
The evidence that you are about to give to this commission is the truth, will be the truth?
Well.
Ms Davidson, you're the Acting Commissioner for Youth Justice?
The Commissioner for Youth Justice recently confirmed.
My apologies, Commissioner. Could you just confirm for the Commission your full name, please?
My name is Andrea Davidson.
You've just told us your position. Could you confirm that the evidence which you will give today will be the truth?
I can confirm, yes.
Thank you. I might just invite Mr Smith first to make any opening statement he wishes to make.
Thanks, Counsel. I want to thank Commissioner Hunter for her welcome to Wurundjeri country, and in doing so, I acknowledge your elders, the spirit of your ancestors, your creation stories, and the ongoing unsevered connection to this place. I further acknowledge that Aboriginal sovereignty has never been ceded on this continent. I've heard the opening statement of Secretary Houghton yesterday and adopt that statement in its entirety. I want to emphasise in particular, though, her acknowledgement of the Department of Justice and Community Safety for its part in the failure to address the shocking and unacceptable overrepresentation of Aboriginal people in the justice system and its failure to prevent Aboriginal deaths in custody. I want to express my deep sorrow and regret to those families and other loved ones that have been left behind. As someone who has lost to the justice system, I know too well that grief. Sorry.
Take as long as you need.
It's an unhealable grief by those that are left behind, that are left without answers and without justice. I also just want to take the opportunity to reflect on Commissioner Lovett's comments from the directions hearing in this place on the 27th of March in relation to Aboriginal public servants. In particular, I want to acknowledge the leadership of people like Uncle Andrew Jacomos, PSM, and Uncle Terry Garwood, who have opened doors and paved the way for other Aboriginal people to take on senior roles in the Victorian public service and make change from within the very institutions that were imposed on our people at the same time as excluding us. Aboriginal public servants often find ourselves in situations where we are the sole voice for change in those settings. But with perseverance, Aboriginal excellence and personal dedication, we continue to strive. It's a strength that's reflected in the tireless advocacy and the fight for our people, for our people since the shits landed. It's in the spirit of that same fight and resolve that went before me that I appear here today to assist the Commission in your endeavour to make historic change. Hopefully, it is a change that sees the future where there are no Aboriginal children or young people in the criminal justice system, because they are strong in their culture, they are connected, they are loved within their communities and their families. This is an aspiration articulated in Gulpa, Victoria's first Aboriginal youth justice strategy, developed under Aboriginal leadership. It's a vision that my youth justice leadership team and the department is committed to realising. Last, can I echo Secretary Houghton's sentiment on the Commissioner's leadership in this groundbreaking work? I want to particularly acknowledge and thank the leadership and strength of the Aboriginal Commissioners for bearing the vicarious trauma that you carry from hearing the truths told throughout this Commission. Thank you for the opportunity to assist you today.
Thank you. Welcome.
Thank you. Commissioner Davidson, is there anything that you would like to say at the commencement of this evidence?
I would like to also deeply acknowledge traditional owners of the lands on which we're meeting today, the Wurundjeri people of the Kulin Nation, as well as peoples across what we now call the state of Victoria, and acknowledge that sovereignty was never ceded for Aboriginal people. I also would like to acknowledge the truth that has been told by many Aboriginal people and their courage, and to wholeheartedly acknowledge the Commission for the landmark work that they're undertaking, and commit fully to telling the truth through my lens.
Thank you. Now, I will direct questions to each of you individually if I want you to answer directly. But if I don't address the question to one of you directly, it will be open to either of you to respond. So firstly, I just wanted to get a clear understanding of the strategic framework within which youth justice currently sits in Victoria. So is it fair to say that the Youth Justice Review and Strategy by Armitage and Ogloff in 2017 provides a launching point for the current raft of changes that have occurred? Is that correct?
That's correct.
It was a substantial review with far-reaching recommendations. From that document, we've seen a number of areas of reform within the youth justice section. And is it fair to say that in overall terms, the Youth Justice Strategic Plan 2020 to 2030 provides a broad framework within which youth justice is now working, or has that been superseded by something?
No, that's right. The strategy sets in place the steps that youth justice is taking to implement the Armitage-Ogloff review. The subsequent development of Wakara Kulpa, the Aboriginal Youth Justice Strategy, is a supporting strategy that helps realise the vision of the Aboriginal Justice Caucus, particularly the Aboriginal Youth Justice Collaborative Working Group, which is a subgroup of the Aboriginal Justice Caucus, and it articulates their aspirations for the youth justice system.
Mr. Smith, first, I would ask you to keep your voice up. Although your answers will be captured on the microphone, we also have people in the gallery who will be interested in hearing your answers, and the commissioners. In the 2020 to 2030 Youth Justice Strategic Plan, there's under the heading Improving Diversion and Supporting Early Intervention and Crime Prevention, within the section headed Furthering Aboriginal Self-Determination and Addressing Overrepresentation, there's a reference to the Koori Youth Cautioning Program, developed as part of the Baralopcha Dungaladja program. Is that still in place?
It's still in place, yes.
And there's discussion, there's a reference in that section to an agreement, the Wangarilwil Gap Aboriginal Children and Families Agreement. Is that agreement still current, or has it been superseded?
That's an agreement that was developed by the Aboriginal Children's Forum with the Department of Families, Fairness and Housing, and I understand that that strategy is still relevant to that department.
But in terms of a more youth justice specific focus, Wakara Kulpa has a greater application?
That's correct.
And so there's four key areas of focus identified for furthering Aboriginal self-determination and addressing overrepresentation in the strategic plan. Apart from improving diversion and supporting early intervention and crime prevention, the second is reducing reoffending and promoting community safety by supporting children and young people to turn their lives around. Thirdly, strengthening partnerships with children and young people, families and all services and professionals who support rehabilitation and their positive development. And fourthly, investing in a skilled, safe and stable youth justice system and safe systems of work. They still hold as the four primary areas of attention for this particular program?
That's correct.
Now, I want to take you straight to the topic of the moment, I suppose. We have heard through media release and also through evidence yesterday that there has been a decision by the Victorian Cabinet to raise the minimum age of criminal responsibility to 12, with a raise in 2027 to 14. You're familiar with that decision?
I am.
And is it correct to understand that some of the work in the lead up to that decision and the work in terms of bringing that decision to fruition will come to the Youth Justice section of the Department of Justice and Community Safety?
We'll have some role in, yes.
Will it be something that you as the Deputy Secretary for Youth Justice lead on, or will it be led from another section of the department?
The announcement was made relatively recently, but it will sit predominantly with Ms Chapman, who you heard from yesterday, who's in charge of the legislative program. in collaboration with the Youth Justice section which I lead.
In terms of that decision, you may be aware from questions raised yesterday that it's been understood that the Aboriginal Justice Caucus and many other advocacy bodies have recommended raising the minimum age of criminal responsibility to 14. Are there consequences that you can observe in terms of raising the age to 12 at this point and not raising the age to 14 immediately?
Consequences for
the Aboriginal youth and children?
I think this is an area that, because of the very strong advocacy from the Aboriginal Justice Caucus and other partners, including the Aboriginal Legal Service, work has commenced preceding that announcement to address the numbers of Aboriginal children and young people in that cohort, in that age bracket between 10 and 14 coming into the youth justice system. And that is very much a piece of, it's a suite of programs that have been in design for some time with the Youth Justice Collaborative Working Group, which is a group of Aboriginal people from the Aboriginal Justice Caucus that work with youth justice specifically focused on Aboriginal young people. And so there are, without the law being changed, there is already a focus, at least in the planning, and it's actually endorsed plan now by the caucus, to start to run out those programs. There is funding that has already been committed to by the government to support those alternatives.
I'll come back to those programs in a moment because we heard some evidence about that yesterday. What I omitted to do at the outset, I'm sorry, in my eagerness to get into the issues, I didn't give you an opportunity just to explain to the commissioners the nature of your role and your background. Mr. Smith, and I'll turn to you in a moment, Commissioner Davidson.
Certainly. So, Commissioners, the role of Deputy Secretary of Youth Justice entails predominantly two arms of work. First is the policy, strategy and performance setting for the youth justice system. And then the second arm is the operations of that system, which Commissioner Davidson oversees in her role as Commissioner. Prior to this role, you'd be familiar with one of the roles that I had, but in terms of what relevant experience I bring to bear in this role, I have a Bachelor of Law that majored in Australian Indigenous laws, a graduate certificate in legal practice and a Master's in public administration. After being admitted to practice, I practiced as a solicitor for the New South Wales Crown Solicitor's Office, here in Victoria for the Victorian Aboriginal Legal Service in their criminal practice, and then in a range of leadership roles across both, across the Department of Justice and Community Safety, the Department of Health and Human Services, as it then was in Aboriginal Health and Wellbeing, and I headed the Aboriginal Affairs portfolio in DPC before moving to Department of Justice.
Thank you. Commissioner Davidson?
As described by Mr. Smith, my role as Commissioner for Youth Justice entails the oversight of the operations of youth justice, both in our currently 2, soon-to-be 3 custodial facilities, as well as across our community youth justice services. So that role sees me closely connected with the operations across the full spectrum of the business, as well as very actively involved in the diversion and early intervention space, ensuring that we divert as many young people as we can away from the statutory involvement with the system. In terms of my background, I've been with the Victorian Public Service now since 2018. The majority of my time with the Victorian Public Service has been spent in leadership within our custodial facilities. However, prior to that, the majority of my career has been based in therapeutic and forensic services within justice, including youth justice in Queensland and New South Wales. In terms of experience that I'm able to bring to bear today, I would say that those historical positions, particularly for me, have had a focus on understanding the stories of Aboriginal people, understanding the drivers of injustice, understanding individual circumstances, and working deeply with community, having had the opportunity to be embedded for a number of years in remote Aboriginal communities. I have really seen firsthand the very detrimental impacts of over-incarceration, and that's certainly something that I bring to bear in the evidence that I provide today.
Thank you. Thank you. Now, I did direct you, Mr. Smith, to the evidence that was given yesterday. One of the pieces of evidence which was given yesterday was in relation to the number of young people in custody. And the Secretary expressed the view that as of Monday, I think, that there were no young people between 10 and 12 in custody, and I think she might have even extended that to 14.
Definitely 10 to 12, there are no Aboriginal young people in custody.
And do you have with you some statistics that you can take the commissioners to?
We do, we provided that too.
Yes. Can we have on the screen a document relating to statistics? Do we have that? Is that the... No.
That's it.
That's it. Now, I might ask you, the writing is quite small on the screen as it stands. Are we able to zoom in at all? Okay. And centre it, please, the text. Okay. Thank you. Now, I might give you the opportunity now, Mr. Smith, to speak to those figures so that they're on the record and the commissioners can hear them from you.
Certainly. So I preface this by saying that there has been incredible work done.
I'd ask you to keep your voice up.
Sorry, apologies. I preference this by saying that incredible work has been done to reduce these numbers, but more work needs to be done. And what we can see from this presentation is that in 21-22, Aboriginal children and young people were 8 times more likely to be in youth justice relative to their non-Aboriginal peers. In Victoria, the average daily number of Aboriginal people aged between 10 to 17 under youth justice supervision, so that's both in custody and in the community, reduced from 122 in 2016-2017 to 55 in 21-22. From July 1, 2022 to the 31st of December 2022, there were 42 Aboriginal children and young people aged 10 to 17 under youth justice supervision on an average day, which is a 24% reduction compared to 2021. It is my view and the view of the youth justice leadership as well as the Department of Justice that these numbers are grossly too high despite that progress. Youth Justice is ahead of achieving its Aboriginal Justice Agreement 4 milestone to reduce the number of Aboriginal young people under youth supervision on an average day by 43 by 2022-2023. So that is to reach a target of 89 Aboriginal children and young people aged between 10 and 17 on an average day. We're also on track to meet our closing the gap target 11, and this aims to, by 2031, reduce the rate of Aboriginal and Torres Strait Islander young people aged 10 to 17 in detention by at least 30%.
And so if I can just ask you a question on that last point. In terms of being on track to meet the closing the gap target, in terms of the trajectory, on those figures, is it correct to say you're ahead of the trajectory?
We're ahead of the trajectory.
Yes. But, so is there any projections in terms of of meeting that target in advance of the 2031 date? Do you know when do you make any predictions as to when you might get there, or is it are there too many variables to do that?
So Ms Davidson might be able to shed more light on this, but I understand that we have met the closing the gap target, but 2031 is a long way away, and we want to maintain that the progress that we've made and exceed it, so that there are no children, no Aboriginal children, young people. That's our aspiration, and that's what we've committed to under Curricle.
Thank you. Is there something you want to add, Commissioner Davidson?
Just in terms of the specifics of that data, so the closing the gap target sees us aiming for 12.3, so 12 young people per 10,000, and at the present time, 2021-22 figures, we're sitting at 9.3 young people per 10,000. So to Mr Smith's point, for us, the target is 0,
Yes.
Unashamedly, and so whilst we are ahead of that target, we also acknowledge that it will be a power of ongoing work that will see us retain and better those figures and drive overrepresentation down to 0.
So if I can just explore that for a moment, a 0 Aboriginal youth population in incarceration, is that premised on the current legislative settings, or does that require some legislative reform to get to that point?
I would say it's an unashamed target, regardless of the legislative environment. That is a target that, in partnership with caucus and Aboriginal community organisations and families and communities, we will maintain regardless of any changes to legislation.
So if we might just assume that the amendment to raise the minimum age of criminal responsibility to 12 next year and then to 14 in 2027 occurs, then, and I accept that cohort makes up a small component at this stage. What then does the department or the commission do in relation to the children in the 14 to 18 bracket? How then do you get to a 0 population without legislative intervention?
So what I'd say to that, Mr McAvoy, is that the focus has been in the current legislative settings to invest in Aboriginal community leadership and programs, and we've seen a progressive investment in those services which are better equipped to work with Aboriginal families and communities to maintain strong connection to culture and family, which are preventative factors for coming into contact with the youth justice system. That's what's seen, in our view, that's what's seen the reduction in Aboriginal children and young people in our system, and we would continue to do that. Is there anything that you wanted to add in relation to?
I think with Karakulpa, what I would say to that, Mr McAvoy, is Karakulpa was built with the vision that it would address overrepresentation for all Aboriginal children and young people. Whilst discussions around age obviously made part, would have been had with caucus, and we do understand their very strong position on that, Wakara Gulpa is focused on all Aboriginal children and young people. So it sets the vision and it also sets the foundation. But I think really importantly, it's unashamedly a dynamic strategy as well. So the strategy itself talks to being one of a number of building blocks that will take us and help us and guide us towards that ultimate aim of 0 Aboriginal children and young people in our youth justice system.
I don't wish to give you the impression that the 0 target is not a worthwhile pursuit, from my opinion. What I'm trying to understand and seeking from you so that the commissioners can understand is it is it a real target, and is it something that you have real intentions of trying to get to, or is it just something that is a statement of principle?
It is a real target that we have all intention of getting to.
So we know that when young children are taken out of the system with the raising the minimum age of criminal responsibility, that has a flow-on effect. That if you can keep them out at an early stage, the chances of them coming back later is reduced. You agree with that? That's what the data tells us?
Correct.
And so when the age is raised to 14, that will have a flow-on effect to the older children. That's correct?
In that, yes. In that, once a young person has contact with the youth justice system, their chances of reoffending and coming back into contact with the system is increased. So if we can stop contact with the criminal justice system in that earlier age, in that 10 to 14 age bracket, statistically it tells us that they are then less likely to come into contact with the youth justice system down the track post-14.
And is it fair to say then that the work that's required, and I'll ask you to try and elaborate on this, is focused on the supporting the children and early intervention work and diversionary work?
Correct.
Absolutely.
And so once they're diverted, are they outside your remit? Do they go to somebody else look after them, or is that diversionary category still part of the Department of Justice and Community Safety?
The answer is both. There are some programs and interventions that we are responsible for in youth justice that are directed at diverting young people away from, further diverting them away from the youth justice system, and that ranges from the programs that we run directly out of youth justice, as well as some of the funded programs that we run through community sector organisations. Similarly, there are a number of other programs like the police cautioning regime that is outside of the control of youth justice, which is in place to divert young people away from the criminal justice system at that point of contact with Victoria Police.
So in terms of the diversionary programs that seem to be working well and productive, can you just, are there any examples that you can speak of to the commissioners to explain what they're doing?
I might pass to Commissioner Davidson for that operational question.
Happy to answer that question, Mr McAvoy. So I think in particular I'd highlight the achievements of the Aboriginal Youth Justice Program. So the Aboriginal Youth Justice Program is a program that is funded, provides funding to ACOs, so community-based organisations. There's a total of 13 Aboriginal community-based organisations that Youth Justice funds through that program. And that work is really focused on providing a culturally safe and responsive service to Aboriginal children and young people within their own communities. So those ACOs are across the state, and certainly some of the work that we've been looking at in the 10 to 14-year-old space in terms of enhancing those opportunities for early intervention and diversion have been around strengthening those services and further funding those services. And that's based on the feedback from our Aboriginal stakeholders and community that those services are working, that there needs to be more of them. And one of the things I think that's particularly successful about that service is the continuity of care that it provides, the place-based response. So Aboriginal young people having Aboriginal workers that are there to walk alongside them from that first point of contact with the system, but also Aboriginal workers who can remain with them no matter where their trajectory heads, so that if a young person then becomes involved in the system, that they're not having to go through changes of workers and alike, which we know can be disruptive to the gains they're making. So those really place-based, child-centred approaches that focus on understanding the individual story of every young person and working through the drivers that have brought them into contact with the system is a really critical part of the Aboriginal Youth Justice Program.
So I ask you this question not to diminish the importance of the feedback you get from community members about the importance and workability of that program, but is there data to support the view that the program is successful?
I think the data that we would primarily talk to is particularly the success that we've seen in the diversion space, so that the reduction in numbers that we've seen has arisen, certainly has been contributed towards by the nature of those support services that are put in place from the earliest point with young people.
And so without referring to a specific case, might you just walk the commissioners through an example of how a child might come into contact with the police and how this process works?
So when an Aboriginal young person comes in contact with the police, there may well be a referral at that point to the Aboriginal Youth Justice Program, or indeed if the young person is to, for example, be subject to supervised bail, that program would immediately be put in place in terms of connecting them with a worker within an Aboriginal community-controlled organisation that can walk alongside them from the point of entry into the system. So what that might look like is supporting them to attend court, supporting them to attend other appointments, supporting them to engage in cultural programs, starting to on an individual level, but also with their family and community, where there are perhaps a young person is not as connected with their culture as they might be, looking at how those cultural connections can be enhanced and supported, and really responding in a way that considers individually what that child needs here and now.
And is that pathway or those pathways well understood by the police involved, or is there a need for further training in that area for police officers?
I couldn't comment specifically on police knowledge, Mr McAvoy, but what I would say is that in the Youth Collaborative Working Group, which, as Mr Smith has spoken about, really underpins the work that we do with our youth, that certainly police are involved in that space and actively involved in that space and attend those meetings and therefore have a broad understanding of the service offerings.
Those meetings are at a higher level. They're not conducted regionally or locally?
No, they are conducted regionally as well, so certainly through the arms of caucus, I would say, and the regional justice forums, etc. There would certainly be police understanding and input, and at a local level, those relationships between youth justice staff and local police.
So can I jump in? Sorry.
Certainly.
So you've got the aspiration around 0 Aboriginal young people or youth in the system, and council's briefly touched upon raise the age. What are the other legislative barriers that are currently impeding on the department being able to work with community to achieve that objective?
It's hard to pinpoint any one legislative barrier. Obviously, changes to the bail laws have some impact on the number of young people, particularly Aboriginal young people, coming into custody. Commissioner Lovett, I would say that some of the barriers are probably more system-wide, not youth justice system-wide, but if you look at the numbers of Aboriginal children and young people that come into our system that are the subject of a child protection, then that I would say that they're some of the barriers I would see and challenges that we would see as a system. We have to address those upstream impacts because there are a number of interventions that could be put in place that are not justice system related before they come into contact with the justice system that would be more effective in my view.
Just following on from that question, though, that that's not to say that there wouldn't be some legislative assistance that could be given within the justice settings. So, for instance, would the achievement of that target be assisted by a stronger legislative framework around cautions and warnings, for instance?
Yeah.
Indeed, it would. Pre-charge diversion, mandatory pre-charge diversion, for example, might be one of those legislative levers that could assist.
And indeed, in the consultations that you have with community, there are a number of areas that might be supported by legislative reform.
Certainly, and I think I'm not sure whether Mr Harrison from the Aboriginal Justice Caucus touched on it in his verbal evidence, but certainly the work that the Aboriginal Justice Caucus did in relation to the Youth Justice Bill. I'm just being careful about how I talk to this because it is some of this is subject to Cabinet deliberation, but certainly the consultation that was done with the Aboriginal Justice Caucus, they put forward very strongly some of those legislative amendments or levers that could assist in that regard. And I think it's either in the Aboriginal Justice Caucus submission or was in the evidence of Mr Harrison, but the way in which we approached that consultation was to fund independent legal advice for the Aboriginal Justice Caucus to draw upon to put together a submission to the department on what those levers might be in any legislation that might be introduced.
And so where all of those, can you say whether all of those were picked up and whether some of those are still work in progress?
What I can say is that the position of the Aboriginal Justice Caucus was put to the department and that formed the basis of advice that we've given to government.
In terms of the matters not within the Department of Justice direct control, you mentioned a few things. One of those is, of course, the education system and ensuring that young people get access to education. And you would be aware that in some places the alternative service model is an education-based model for under children under the age of criminal responsibility. You're aware of that?
In other jurisdictions?
In other jurisdictions.
Yes.
Can you speak about how you relate to the education department and ensuring that children get access to schooling through their experience with the criminal justice system?
Certainly. So it would depend on whether the young person is in a community setting, so under a supervised bail, or a community disposition, or whether they are in custody. In relation to the young people in community, there would be a care team in place. As part of that care team, regular convening of that care team, a plan would be put in place to ensure that that young person maintains engagement with their school or education facility. In custody, the Parkville College model is in place for all young people in both Malmesbury Youth Justice Precinct as well as Parkville Youth Justice Precinct. So that's a structured, individualised education approach to each young person.
Is that are those education services on par with children in the regular school environment?
It's structured in a way. These programs are run by the Department of Education in our in the facilities that we run. The underpinning principle for the Parkville College model is to meet the young person where they are in their education journey. So it recognises that a young person might have already disengaged from education and might need remedial work to re-engage. And so that assessment is done through the Parkville College to understand where they are at and what individualised or tailored education services they might need in that setting. And then that will form part of their structured day in custody.
Correct me if I'm wrong, but it is the case that there is a degree of overlap between disengagement from the school environment and interaction with the criminal justice system. Yeah,
that's absolutely right. And counsel, if I could draw attention to the Task Force 1000 work that Commissioner Giacomos did in his former role as the Commissioner for Children and Young People. He did a review of the 1,000 kids, as it then was, of Aboriginal children in child protection and out-of-home care. And what that task force found was that of those kids in care, a large proportion of them had contact with the youth justice system, and a large proportion of them had disengaged from educational settings.
Thank you. I expect that, particularly following on from your previous responses in relation to your discussions with the police, that there are ongoing discussions with the police about extending the diversionary systems and cautioning to the older children, the young people. Is that correct?
What I'd say, Mr McAvoy, in designing any new legislative levers that might be part of a new youth justice bill or act, we would engage with Victoria Police on the bits that are relevant to them.
It's also well known that there is a strong correlation between homelessness and housing difficulties and young people involved in the criminal justice system. Is there something that you can say to the commissioners about what your department is doing in order to address that particular issue?
I might get Commissioner Davidson to speak about the Priority Housing Program, which I've forgotten the title of that program's name. But Mr McAvoy, to the proposition that, particularly for Aboriginal young people, but I think this applies to young people generally in contact with the youth justice system, stable accommodation and housing is an issue for those young people, and suitable placement options post-release is a continuing challenge for youth justice.
What I would talk to there is particularly, Mr Smith earlier had referred to the care teams that wrap around a young person. So there are many factors that young people that come in contact with the youth justice system, many vulnerabilities that we see. Housing, homelessness is certainly one of those. Educational disengagement, mental health concerns, drug and alcohol issues, involvement with the child protection system. So the care team approach that we take once they have contact with our youth justice system is to, at the ground level, be bringing all of those different stakeholders together, including our staff, very importantly, from those Aboriginal youth justice programs that I mentioned earlier, or if the young person is in custody, from our Aboriginal liaison team, to ensure that each and every one of those individual factors is being considered and actions put in place specific to that young person to resolve those difficulties as much as is possible.
Excuse me, Ms Davidson, can I just ask, that sounds wonderful. Do all young people that come in contact with the criminal justice system get that
Yes, they
team?
do.
So
Yes,
it's
they do.
100% applied?
Absolutely. So all young people who are under any form of statutory youth justice supervision. So, for example, if they were to come into custody, within 1 week there is a care team facilitated for them, whether we have prior knowledge of them or not.
Sorry, Commissioner Walter, can I just clarify that, though, that if it's just an interaction with Victoria Police and they aren't charged or found guilty, then there will not be a care team convened by Youth Justice for those?
Is that a gap, Mr Smith?
Well, it would depend on the circumstances of that young person, because a lot of children and, you know, middle-class white children come into contact with the police system or the police force and don't need a care team. And for those Aboriginal children that do come into contact with the police system that also have, you know, a loving, caring, thriving home, then probably not. You would rely upon the family dynamic to help with putting in supports for that young person. But in terms of where there are more problematic environments, I guess, for that young person at home, then more interventions around that family could assist.
I think one of the big challenges, Commissioner Walter, is we want to avoid bringing young people into that statutory element of the system. So absolutely appreciate it's about getting them the right supports at the right time. It's about, I guess, the facilitation of those supports.
Can I just ask, in that care team, if they've already had contact or are in care, is there someone from the agency that looks after them from out-of-home care within those care team meetings?
Yes, so child protection, and also if they were, for example, in residential care, that provider would be a member of that care team.
Thank you.
So the trigger for your involvement, though, is some interaction with police, is it?
The trigger would be well, that would be one of the triggers, but it would be progression from interaction with the police to some kind of statutory order. So whether it's supervised bail or a community, an imposition of a community disposition by a court, that's when they would come into the purview of youth justice.
So if a young person is given a caution and they're not dealt with by way of court proceedings, is there any service that picks up that person for that period?
So those young people could still be referred to the Aboriginal Youth Justice Program. So that program is able to cover the full scope of a young person's potential contact with the system, and within that diversion and early intervention frame, those services can certainly, funded through Youth Justice, can certainly continue to remain involved in supporting the young person and their family.
So one of the things that you referred to earlier was trying to ensure that there was some continuity of care, and that once a worker was assigned to or a team assigned to a young person, that they would then be able to stay, hopefully, with that person?
Yes, that's correct. So in the instance of a young person perhaps who doesn't have a statutory involvement with youth justice but is involved in the first instance with the Aboriginal Youth Justice Program, if that young person then progressed to statutory involvement, that worker that has had that initial contact would retain that contact with them in terms of continuity of care.
The Commission has heard evidence in relation to the child protection area and out-of-home care. Some of that evidence has suggested that there's a reasonably high turnover of staff and difficulties with continuity of care and development of relationship with workers in that environment. Is it different in youth justice? Are there community-based supports able to provide a more continuous support?
What I would say is I don't have the specific workforce data within those ACOs themselves, but what I would say is that there is a stability of service within youth justice community in particular. I don't have the specifics of workforce within those ACOs, but certainly the impression that I get from the youth justice case management review panels, as well as what I hear from community is that there is, particularly with those workers and the depth of knowledge that they have around our young people, that there is stability within that broader ACO service system in so much as I have view across.
Mr. Smith?
To more directly answer around the youth justice workforce, so the community youth justice workforce in our employ, it is a more stable workforce than I heard Mr. Alessandros's evidence suggest for the child protection workforce.
One of the objectives that's outlined in the strategic plan is to invest in a skilled, safe, stable youth justice system and safe systems of work. So, I mean, in formal terms, there's a recognition that skilled, happy staff assist the outcomes. Am I overstating that?
No, that's right. And in opening the Cherry Creek Youth Justice Facility later this year, we are moving to a different workforce model with an uplifted workforce, so a more qualified, more highly paid workforce that is trained as a bare minimum. They'll have a certificate for in youth justice and trained in our communities of practice model, which is also a recommendation out of Armitage Ogloff. To ensure that we have a more behaviour-based intervention approach. It has a higher staff to young person ratio so that we are better able to support a young person, address their offending behaviour, rehabilitate and re-enter back into community.
The creation of a new centre, the employment of additional staff, that clearly has funding implications for the department. Is it the case that the programs and services that are being recommended to the department by the community, the Aboriginal Justice Forum or the Aboriginal Justice Caucus, requires substantially more funding than is presently available in the youth justice area?
I would think greater investment across the spectrum of Aboriginal services is needed, from family services across the spectrum, youth justice services delivered by those Aboriginal community-controlled organisations. And if we are genuine about moving to Aboriginal community control as a means to address the issues that plague some of our community members, then I suggest greater investment in those services is the way to go.
Can I just ask, just on funding, the Aboriginal Youth Justice Program funding that you talked about before, and it's the program, how is that funded? And is it recurrent funding?
So it's a mix of funding streams. Commissioner Walter, the Aboriginal Youth Justice Program is baked in, so it's recurrent funding for components of it in youth justice generally. So the Aboriginal Youth Justice team that sits within our central functions, headed by an Aboriginal Director of Youth Justice, that's part of our recurrent funding. Some of the program-specific money that we talked about earlier around that focus on family-led interventions for that cohort between 10 to 14, that's new money that was announced in a recent budget. It's either 2021 or 21-22 budget that's specific for those additional services.
I guess my point is, do the ACOs that are providing this service, who are central to it actually being available and working, do they have surety of funding, and is the funding adequate for them to provide the quality services that they need to provide?
I would say that there's been consistent and ongoing funding for the Aboriginal community-controlled organisations that we fund, but I would acknowledge that not every Aboriginal community-controlled organisation across the state is funded to run youth justice programs. So there are some organisations like MADAS, so Mildura Early District Aboriginal Service, for example, they receive more money on an ongoing way because of the recognition that they have a bigger population in that centre as opposed to somewhere in sort of, I don't know, Far East Gippsland, for example. We might fund those organisations differently or fund one organisation, not another. It's based on need, advocacy and availability of resources.
So it's not, so it's not a statewide program? Like, do you have to be in certain regions to get that support?
So the Aboriginal Youth Justice Program is a statewide program. The funding of ACOs is dependent on where the ACO is and what services they deliver or want to deliver for that community. But for example, in Ringwood, we have an Aboriginal focus team within Youth Justice that provides culturally specific supports to Aboriginal young people in contact with the youth justice system in community settings in that region. So they have access to culturally appropriate supports in that area, but it's not delivered by an ACO. So the distinction is where does the funding go and who is it delivered by? And it depends on the location and the specifics of that community makeup.
Would you say it's a statewide program? So wherever you are, you have access to it if you're Aboriginal youth who needs access to it?
You will have a worker walk beside you.
Great, thank you.
Can I jump in? I come back to that, not to take away from the aspiration internally and the work that you're doing with the Justice Caucus on zero, but the new Cherry Creek Youth Justice Centre. If the government is looking to raise your age of criminal responsibility to 14, why is it at the same time increasing the number of youth justice facilities under your responsibility, which presumably means greater capacity to incarcerate more of our people? The data says that our people are overrepresented, and yet they're investing in more youth justice facilities, 2 to 3. And I get that you're wanting to do more stronger care plans for people going into this new facility, but we're not doing that already in the current facilities to the level.
Yeah, and Commissioner Lovett, you're absolutely right. With the commissioning of the new Cherry Creek facility, so we're funded for 56 beds within that facility. We'll take the number of available beds across the 3 precincts to in excess of 300. We have 100 kids, both Aboriginal and non-Aboriginal, in our precincts today. So the configuration of the system is a matter for government, what facilities are funded. But what I would say about the Cherry Creek facility is that it does allow the system to flex to better support kids that do come into custody. And what I would say about that, the cohort that does come into custody, and this is a general observation about all kids that come in, not just Aboriginal kids, is that we are getting better at keeping young people in community, whether they are within the case management responsibilities of youth justice, but the ones that do come into custody are increasingly more complex. And so having a facility that is equipped and a workforce model that is equipped to deal with that complexity, as long as the kids are, as long as it's the position of the justice system that we have facilities to incarcerate children, it's, in my view, better to have a fit-for-purpose facility with a fit-for-purpose model that is better focused on rehabilitation than older models.
You've got to understand our hesitancy around the ongoing systematic injustices our people have faced. I mean, the data's there. So,
absolutely agree with you.
At the same time, the level of optimism is a little bit different on this side of the table.
Can I just add to Commissioner Lovett's point that it's very contradictory to say we're going to raise the age of criminal responsibility, we've got these programs, we do early intervention, but then build a new facility. Do you agree?
I agree.
We actively acknowledge that, Commissioner Hunter, and it certainly has been a view expressed, understandably, by Aboriginal stakeholders and community. I think further to Mr Smith's point around Cherry Creek in particular, the design of Cherry Creek is really in part about acknowledging the extreme vulnerability that young people experience when they come into custody. And the facility itself has been designed in terms of both the built infrastructure as well as the models of care to be really attuned to that vulnerability and to be able to provide as much safety, both physically and culturally, and in terms of the programs that we provide in that space. So whilst we absolutely acknowledge on face value the comments that are made, and it's certainly not cause for celebration to be opening a new youth justice facility, what Cherry Creek will be able to provide is a far more nuanced service that is able to be responsive to young people and really wrap around them in a positive way when they come into custody to support them through that very difficult time.
So what about the kids that are currently at Malmesbury and the kids that are currently at Parkville? What happens?
Yeah, so there's a pretty developed placement model for young people that are in custody, and so that goes to having some headroom in the number of beds that we have, so that we can appropriately place young people that are in custody, so that they are receiving the services that they need or should get, as well as ensuring their safety. So things like age group, whether they're sentenced, gang affiliation, for example, those are the considerations that we take into consideration when deciding where a young person should be placed in a facility. Malmesbury, for example, has the I'm not sure whether the commissioners went to Malmesbury. Yeah, so the Malmesbury is unique in that it has the dual track program run out of that facility, which is the open site for 18 plus people, young people, to participate in that unique program. So there are different offerings, I guess, from each of those precincts. For example, Parkville and its proximity to specialised health services, the children's, that might be a more, for a young person that has complex health needs or the like, needs access to the paediatricians, that might be a more relevant placement in that facility than Malmesbury, for example. So these are some of the considerations we take into account when placing a young person. But Commissioner Lovett, your point is not lost, that custody is not a place for young people, and we openly acknowledge that.
Just following on from Commissioner Hunter's question, Mr. Smith, I understood Commissioner Hunter's question to be asking whether young people from the existing facilities will be housed in the new Cherry Creek facility, whether there's going to be any transfer to that facility when it's opened, or the impression that I've gotten from your answers so far is that it's about housing new people into the system with complex problems.
No, that's sorry. I didn't mean to give that impression, Council. So there will be some transfer of, in fact, it'll be transfers from our existing facilities to Cherry Creek in at least the first instance. The numbers of young people that are in custody is maintained relatively steady at around 100 young people, and so. The number of young people coming into contact with the justice system wouldn't warrant just putting new people into Cherry Creek. So there will be a progressive transfer from the other facilities into Cherry Creek once it comes online, and the placement of those young people will be based on their specific needs.
So the placement of young people within youth justice is facilitated through a placement panel, and that placement panel considers their individual risks and needs and circumstances. Consideration is also given to the mix of young people in any particular unit or location. So that placement panel is attended by Aboriginal liaison officers, by a manager of Aboriginal Youth Justice Operations, so that consideration is given in each and every young person's case as to the most appropriate, safe placement for them. Cherry Creek will now be one of those options.
Can I ask what kind of cultural programs will be provided to Aboriginal people who at this facility? Because we've heard from many people by going into prisons and youth justice facilities that they feel that they're rolled out at NAIDOC week to do a dance for everyone, but beyond that, there's no cultural plans happening for them, and maybe a bit of an art class here and there. So can we just get a understanding from you around what programs, meaningful programs?
So absolutely. I think at the heart of the services for Aboriginal young people at Cherry Creek will be our Aboriginal Liaison Officer team. So young people at Malmesbury and Parkville have access to that team, as will young people at Cherry Creek. In terms of a young person's cultural journey while they're with youth justice in custody, and that particularly that place of vulnerability, often dislocated on the whole from their families and communities, that Aboriginal liaison officer is the person that walks alongside them and that really looks at what programs, what research, when I say research, what can we do to support Aboriginal young people in their cultural journey during that time, but also what are some of the risks around that. So we know that obviously every young person is on their own journey, and we know that for some of our young people that come into custody, they can feel quite vulnerable in terms of looking at some of those matters while they're with us. However, it may be about, for example, introducing a connection in community that they're not aware of and starting to build that connection with an ACO or with the VACA Youth Through Care initiative during that time. In terms of dedicated programs through Parkville College, all Aboriginal young people in custody are able to access a dedicated cultural education program where they can come together in a culturally safe space, led by an Aboriginal teaching facilitator, as well as supported by those ALOs who walk with them throughout their time in the system. We do also have at Malmesbury at the moment, for example, Uncle Ron Murray comes in and spends a lot of time with our young people, again, working with them where they're at on their journey. In youth justice, having a cultural support plan is not mandatory in the same way as it is in child protection. However, where particularly young people are with us in custody for a longer period of time.
What does that threshold mean? Longer period? 6 months on, 1 year?
It's completely dependent on the individual young person. I can just reflect on my experience that certainly where young people have felt safe and are wanting to have a cultural support plan developed for them, it has generally been when they've been with us for a bit longer, they're feeling safe in their relationship and they've built a relationship with our ALO, and they feel that sense of safety and understanding in terms of wanting to do that work around developing a specific cultural support plan. Where a cultural support plan is developed for a young person, for example, in custody, that is then transitioned with them back into community, and will continue to be able to inform cultural support services that may be provided to them. But that is also done regardless of a cultural support plan through that care team process.
And you referred to, thanks for that, you referred to the Aboriginal Liaison Officer position. So what authority does that position have? Because we've also heard barriers from, people around asking for things and then having to go to the Aboriginal Wellbeing Officer in prisons, for instance, and then them not being able to generate any kind of action or movement towards what they're after, within a reasonable ask, obviously.
Yep, absolutely. So the Aboriginal Liaison Officer team is oversighted by a manager of Aboriginal youth justice in custody. So that position sits on the custodial executive. That position is front and centre of all of our meetings as an executive and is the point of accountability within the custodial system as to the treatment as well as the opportunities and services that are provided to those Aboriginal young people. So certainly reflected within our structure is the authority of that team and particularly that manager position.
Yeah, thanks. I'm really concerned because a lot of the time there's a Indigenous garden there and that's about all they get access to.
Yeah.
Our culture is deeper than just a garden.
Yeah, and Commissioner Lovett, I would say that the seriousness in which we focus on Aboriginal connection for our young people in youth justice is reflected in our structures as well. So we have a dedicated, as I said before, we've elevated that portfolio to an executive portfolio within youth justice. So there is a dedicated executive officer, an Aboriginal executive officer that oversees those programs both from a community and custodial setting. So we want to ensure that at all levels of youth justice there is Aboriginal voice from our staffing cohort, and that the Aboriginal young people themselves, their voice is heard as well. And certainly through the development of Wakara Kulpa, we engaged the Koori Youth Council to engage with young people in both in youth justice and more broadly around what they want to see in that strategy. So we are absolutely mindful and committed to hearing Aboriginal young people's voices in that. In relation to cultural support plans, as Commissioner Davidson said, they aren't mandatory. They are offered to Aboriginal young people. There is recognition, though, that if you are a child in child protection, you also should have a cultural support plan, and there might be inconsistencies between a YJ cultural support plan and a child protection cultural support plan, and the process around building those plans might be disjointed. So there is work underway that is funded. We've engaged an Aboriginal consultancy to do some work across both of those systems to design what a consistent cultural support plan across both of those systems might look like.
Yeah, I agree. I mean, it's still, I get it's not mandatory, but it's still should be seen as a minimum service level requirement for our people, at a minimum, that they get that service. Thanks.
Mr McAvoy, can I just ask some questions about things we were told by young people in both prisons and in detention centres? Firstly, in relation to maintenance of staff numbers while Cherry Creek is being established, we were told by a young person at Malmesbury that he and a young Aboriginal person, that he and others were experiencing long periods of lockdown due to staff shortages, which he associated with the establishment of Cherry Creek. Could you give me some information about whether that's happening, what's being done about it, and where to from here?
Absolutely. I would certainly acknowledge that we have had workforce challenges in youth justice that have been quite acute in recent times. In custody, sorry. Acknowledging workforce challenges across the board, but particularly those have been acute for us, and we acknowledge that. As to the connection with Cherry Creek, I wouldn't make that connection per se. However, I think the challenge of attracting staff to work in youth justice facilities and attracting skilled, capable, the best possible staff that we can has certainly been enhanced at Cherry Creek through a workforce model that both, frankly, pays staff more for the very difficult job they do, but also that makes it very clear that their role is about truly being engaged and invested in a young person's journey in youth justice and in the case management of those young people in particular. So, for example, the uplifted workforce model will see the key worker that's assigned to a young person in custody, along with the ALO for an Aboriginal child or young person, attend their care team meeting and be actively part of that, in acknowledgement that those staff working with those young people for more hours of every day and week than any of us in the system. So investing in not only their capability and development, but really elevating their role within the system to be able to support young people in a particularly rehabilitative frame is a critical part of Cherry Creek. We continue to look at all of the levers that we have from a workforce perspective to stabilise our workforce and to be able to avoid any isolation for young people in custody. We know it can have detrimental impacts. We absolutely want to avoid it, and wherever we have to, due to staffing pressures, engage in isolation practices, we do everything we can to ensure that we're wrapping around that young person and protecting their human rights in so much as possible within that setting. So, for example, in every circumstance of isolation, an Aboriginal liaison officer is advised of that isolation and is providing services to that young person, so coming in and supporting them during that time, and particularly supporting them when they're coming out of isolation as well. The approach that we take to isolation also aims to minimise the period of time. So rather than young people, for example, spending 4 continuous hours in their room, if that's a requirement because of a staffing pressure on that day, we would look to split that isolation to different points in the day so that we're minimising the continuous isolation. But throughout those times, consideration has to be given through our processes to the supports that are put in place, given the vulnerability of young people in those circumstances.
Thank you.
Following on from that question, are lockdowns occurring at the moment?
Yes, lockdowns are occurring at the moment.
week?
I'll acknowledge that.
Last week?
Staff-related.
Staff-related
Lockdowns?
lockdowns. Yes, they have been.
So I understand that the decision to construct a new facility is something that might have a relatively long lead time. Was the construction of the Cherry Creek facility the decision made in response to other difficulties in the current youth detention facilities?
Not specifically. What I would say is that the Cherry Creek facility was built with having in mind a purpose-built, very contemporary purpose-built facility that's able to best meet the needs of young people.
But it's not going to be a replacement for any of the existing facilities. No proposal to cut any to close Malmesbury or Parkville.
In terms of system configuration, that's obviously a matter for government. As Mr. Smith has alluded to, there's certainly more beds than young people in custody at the moment.
And reading between the lines of your evidence, the ability to pay more and attract a particular type of staff to Cherry Creek, that's tied to having an uplifted staffing model, so bringing in somebody with the greater skills. Is that right?
Certainly what we've heard from staff that have been employed at Cherry Creek that had also applied for Parkville and Malmesbury. So when someone is making an application for youth justice, they can be specific to a facility or they can put their application in across the board. For those staff at Cherry Creek that had applied across Cherry Creek and another facility, what they have reflected to us is, yes, pay is an important part of the question, but the nature of the role is also for them what was most appealing and why they selected Cherry Creek, often requiring a longer commute for them, but for them the nature of the role and that ability to be able to do their best work with young people on the floor and be actively involved in their case management care teams was highly appealing.
And I think the other thing that I would add to that, Mr McAvoy, is the location of Cherry Creek. So it's in a growth corridor of Melbourne. It's based between Werribee and Geelong, two of the biggest, sort of fastest growing areas in the state. So the pool upon which you can draw a workforce for that centre is far greater than a place like Malmesbury.
So some of what you've learned in relation to establishing Cherry Creek, is that being transferred back to the other facilities in terms of creating a better environment for the staff?
So the uplifted workforce model at Cherry Creek is obviously the flagship for that site at this point in time in terms of that workforce model and what it looks like across the rest of the system. That is a matter for government that they're currently considering.
Yeah, but in terms of what we can do and with the levers that we have available, so things like the communities in practice we're trialling at Parkville, and Ms Davidson can talk more to that model or more articulately than I can, but in terms of the practice, the elements that we can transfer over, putting aside the pay rate, we will transfer over we are transferring over to Parkville.
And I think
Clearly, having regular lockdowns in a youth detention facility is unsatisfactory. You would agree with that?
Yes.
Great.
And so something has to be done. It's not a long-term solution to have ongoing lockdowns and isolation of young people.
Yes, we acknowledge that.
So how do you achieve that? If you're bound by awards in terms of what you pay, and you can't employ enough staff to conduct the facility in a safe manner for staff and for the young people, what do you do?
It is a very complex and wicked issue. I think one of the keys for us is being able to recruit but also retain staff. I think what we have seen is that under the current settings at Parkville and Malmesbury, often working in our custodial facilities is a stepping stone for staff to other locations. I think to Mr Smith's point around ensuring that other reform activities are enhancing the service models, but also the conditions for staff in our two facilities, that's a really important point. So particularly the communities in custody model will, regardless of pay scale, see our staff working in a far more individualised, nuanced way with young people, and particularly with a focus on the least restrictive environment. So considering how we're able to work with young people within our custodial system in a differentiated way, and engage in things like, for example, leave programs to the street cafe at Parkville, those sorts of activities that enhance outcomes for young people but actually enhance the experience and the role for staff themselves.
Can I just ask, how long has this been a problem? How long? Years?
So I would say it's been particularly acute in the last 6 to 8 months. Prior to that, we absolutely had periods of stability where we had no lockdowns whatsoever across our system. So it's, I guess, the drivers of the acuteness of that problem are what we're working through at the moment. And that doesn't mean that we are sitting on our hands and waiting. We are pulling
No,
every
I
lever
understand
we
that,
have.
but when in lockdown, do the young people get their educational programs?
So they have access to education. That's absolutely one of the considerations. What that access looks like can be
Under
quite...
lockdown, does it look the same or does it look different?
Oh, it certainly looks different, but it looks often like young people coming out of their rooms for a shorter period of face-to-face time with teachers. Often what it means is teachers are on a young person's unit. So it may be that when a young person is in their room even, that a teacher is interacting with them, and that interaction may be around just generally checking in with them, how they're going, but also the provision of particular pieces of work. Where young people were in lockdown for COVID, for example, which were particularly pointed lockdowns for young people, to ensure that we were able to, as much as possible.
More interested in right now.
Right now. So certainly we are continuing, and we absolutely endeavour to provide them with not only education, but other, I guess, developmental opportunities whilst they are in those
So
circumstances.
to be clear, the high level of lockdowns right now are having an impact on the education that these young people are receiving.
I would accept that.
And what about their own human rights? Is there a breach of human rights here?
So we, through every element of our operations in youth justice, we give careful consideration to the Charter of Human Rights. So all of our custodial staff, as part of their Certificate 4 in Youth Justice and their induction prior to that, were educated around the Charter. And certainly where there is circumstances such as lockdowns that impact or have the potential to impact, we look at every entitlement that can be put in place to limit the impact of that. So, for example, when young people are locked down based on dynamic risk assessment, where it's for a staffing reason or otherwise, a plan is put in place to provide that young person with support whilst they are are in their bedroom. So generally isolation is also occurring to a young person's bedroom, so they are within a familiar environment. But we are looking to do everything we can to support them whilst they are experiencing that lockdown and to limit the period of time that lockdown occurs for.
Would you accept that there are several human rights engaged? For example, the right to be treated with dignity when in custody? Would you accept that the right to be free of inhumane treatment at any time, including when in custody is engaged?
The full Charter of Human Rights, absolutely.
I want to be specific about it because I think it's necessary to understand the dimension of the problem.
Yep.
And the right of a child to be treated having regard to their best interests.
Yes.
And other rights.
Yes. I think the difficulty for us at times can be, Commissioner Bell and I absolutely acknowledge those rights, and it is our express job to ensure that we are giving young people the opportunity to exercise fully their rights as much as is feasibly possible.
Look, I accept the sincerity of your evidence, but what we were told by young people is that they were experiencing very extensive periods of lockdown, which prima facie is a breach of all of the rights that I've just specified.
I think one of the elements of consideration that I would draw the Commission's attention to is obviously the right to safety, and that is very much a consideration when we are looking at making a decision around lockdown. So we do have to maintain the safety and security of our facilities. And
that's true. I understand that because of lack of staff, there may be an environment that's not sufficiently supervised within the detention environment. I understand that. But that's created by the staff shortage in itself. And I have to ask you the same question that I asked another witness in a similar situation the other day, which is how on earth staff shortages can be put forward as a reason for fundamental human rights violations.
I appreciate the point that you're making, Commissioner Bell, and I can only turn to the complex decision-making when it comes to considering how to ensure that a custodial environment is safe and secure.
Do we appreciate the comment? Sorry to jump in. Do we appreciate the comment, or do you accept it? I think it's two different things.
I accept the comment.
Thank you. Sorry.
One other subject, and I'll be brief, Counsel. We visited Malmesbury. We also visited Marginheat and other prisons in the west of Melbourne. In both places, we spoke with young people who were old enough to be either in a youth detention centre or in a prison.
Yes.
Concerningly, we were told the same thing at both ends. One young person at Malmesbury said that he successfully sought a transfer from an adult prison because he thought he would be able to access programs at Malmesbury. He was bitterly disappointed that he was not, and he told us that he regretted making the decision that he'd be better off in an adult prison. At the other end, in Marginheat, or one of the other prisons in that direction, we were told by a relatively young offender that he had decided not to seek a transfer into the youth detention system because he'd heard that it was not possible to obtain access to the kind of services which he felt he could get in the adult environment. I wonder if you could comment about that.
What I would say in the first instance is that I accept that evidence, and I would say it's not good enough. We absolutely want to be in a position in youth justice to be able to provide services to and support to young people across the spectrum of what it is to be a young person. So the dual track system in youth justice in Victoria is in many ways the jewel in the crown, that we do have a state that recognises the vulnerabilities amongst young people up until sort of the age of their development, which certainly science considers them to be an adult. So I think it's very disappointing to hear that those views have been shared with the Commission, and I openly acknowledge that it's not good enough.
Sorry, Mr McAvoy, just quickly. There was a inquiry called The Same Four Walls back in 2017.
Yes.
And that was the inquiry examines use of isolation, separation and lockdown in youth justice. Now, if I go down to one of the recommendations, this is from 2017. There is one particular one on lockdowns, that DJR immediately review the youth justice staffing and recruitment model to ensure that the sufficient suitability trained staff available to supervise children and young people to prevent frequent and extensive lockdowns. So I'm assuming that recommendation wasn't implemented.
I was going to say, so there.
Just so you know, because I already knew of this, so you can also take it on notice, because I know Mr McAvoy may not have brought this up with you, if you want to.
No, that's fine. I'm very familiar with the Same Four Walls report, and I think it's a really important question that you ask, Commissioner Hunter. Youth justice, following on from the Same Four Walls, but also the Armitage-Oglov review, have implemented a workforce, or we are in the process of implementing a workforce strategy. Now, as I alluded to earlier, we have had periods of time at Malmesbury and Parkville where we've seen the benefits of the initiation of that workforce strategy. So, for example, the provision of a certificate for all our staff, and what we are seeing in terms of the uplift of capability. But I do acknowledge that we continue at this point in time to see lockdowns that are unacceptable, and that we need to do better.
It's just 2017, it's now 2023. And as you'd appreciate, as Commissioner Bell pointed out, the kids are still saying they're being locked down. And we know from the research and the information gathered that it's just not good enough.
Well, if I can take that one step further, thank you, Commissioner Hunter. Experience tells us that extensive lockdowns are often precursor to disruption events, the rioting in youth facilities. You're aware of that, obviously.
Yes.
That's something that's happened in many places around the country. And would you accept that continuous use of lockdowns as a safety measure, a mechanism for managing a youth detention facility, raises the risk of that type of rioting event?
I do accept that risk, Mr McAvoy. I absolutely accept that risk, and that is the very challenging job that we face every day in looking at the decisions that we make around any isolation of young people. What I did want to put forward from a statistical perspective, and this is not to at all downplay the impact of isolation, because any isolation of young people from our perspective is not good enough, in an area which we need to focus on improving. But the periods of isolation on average that young people are experiencing have gone down overall, and certainly we have seen fluctuations in that, and I acknowledge it. And I acknowledge at this point in time that we are seeing a fluctuation for the worst. But we continue to strive to work hard to correct and get back to where we were at a point in time not too long after the implementation of the workforce strategy, where we did see a level of stability. And we're very hopeful in particular that the uplifted workforce model at Cherry Creek is going to have an impact on that, and certainly in terms of the recruitment of our custodial staff to that facility, we're seeing some really promising results.
At the moment, we've got issues at Malmesbury and Parkville, and in response to my question earlier, Mr Smith talked about providing a better workplace environment as a mechanism of encouraging more staff to take on those roles. But my appreciation of the better workplace environment really leaves me thinking that it's a chicken and egg type scenario, that you in fact need additional staff to be able to operate in a manner that makes it more conducive to people wanting to work there. Is that correct?
That's correct.
Sorry?
I would say generally that's correct, yes.
Thank you. Look, Commissioners, we've been going for an hour and 50, for some time. if we could take a short break now, I think we will then go through till a 1 o'clock lunch break.
Can I just quickly ask before we go, with the same 4 walls, would you be able to supply us with what recommendations have been implemented from that? That would be great.
Absolutely.
Thank you.
Thank you. 15 minutes.
Thank you.
Thank you very much. Adjourn, 15 minutes. 10. Shall we resume?
Thank you, Chair. I have some questions following up from before the break, but I just wanted to confirm for the record, Mr. Smith, that in terms of your prior experience in work, you were a CEO for the Yoorrook Justice Commission.
I was, yes.
Thank you. Now, following on in part from the discussions before the morning tea break, I ask what provisions are in place or otherwise for holding young people in adult facilities? Who can answer that?
I think we both can. The broad provision from which a young person, so the power to transfer a young person from a youth justice facility to an adult prison rests with the Youth Parole Board, and that's a power that they exercise under Section 467 of the Children, Youth and Families Act, and there are a number of considerations that they are required to take into account to make such an order. It might also be the case that the gravity of offending for a young person means that a court might sentence a young person to an adult facility in the first instance.
And what about in circumstances where, for the relation to the security of the facility, where we've seen in the past young people held in adult facilities, and that you're aware that that's been the subject of litigation? What circumstances might that arise in the future?
The circumstances under which it arose, as I understand the litigation that you're referring to, Mr. McAvoy, the decision to transfer in that case, as I understand it, was before my time, was found to be improper, and those kids were transferred back. So, accepting that, the circumstances under which, and some of the circumstances which the Youth Parole Board are required to consider in transferring a young person to an adult custodial setting, one of the factors would be the security risk that young person proposes to a youth justice facility.
And that's the only path is through the youth parole.
That's right.
Correct.
Yes.
Now, there is before we leave the discussion, which I think was sparked in part by your evidence related to the Cherry Creek facility. Before we leave that, clearly the cost of construction of a new facility and staffing is significant. As I understand your evidence, there are presently approximately 100 youth detainees in total.
Today there are exactly 100.
And the addition of 56 beds at Cherry Creek, I think you said 56,
yep,
takes the total beds to 300 or
330 approximately.
Yeah, 333.
So there's additional space in the system for additional detainees, if I can put it that way. Very crude, I accept. But the expense that's been put to construction of Cherry Creek, when we've got staff shortages, we've got rolling lockdowns, where you accepted earlier that there's always a need for more resources in the system to fund diversionary and other community-based activities. Is the construction of a new facility consistent with all of those other needs in the system?
Mr. McAvoy, I would suggest those decisions are more decisions for government. Certainly, as an Aboriginal community member, I have some views on that proposition, which I won't offer in my role as a public servant. But
if I can put it this way, what view does the Aboriginal Justice Caucus have about that expenditure on a new facility?
They've made it quite clear at the Aboriginal Justice Forum, and without sort of verballing Narita Waite from the Aboriginal Legal Service, she's made it abundantly clear her views in relation to the investment in new custodial facilities, not just youth justice facilities, but other new custodial facilities, versus the investment in other services that might be based in community.
If I can just take you back to some of the issues we covered this morning. It seems that some of their success in keeping very young people out of the system is a result of the exercise of discretion by police officers. Is that correct?
In some circumstances, yes.
Well, what other circumstances are there apart from the use of cautions?
Well, it depends on how far up the sort of spectrum you go. If, for example, there is a young person that might have some risk factors of coming into contact with the youth justice system, and they are actively engaged with a local Aboriginal co-op or a community organisation, the interventions and supports that can be provided by those organisations and those individuals at that organisation might deter or prevent that young person from coming into contact with the youth justice system. But I accept your point that the discretion of a police officer in some circumstances does have an impact on where a young person might proceed to next in terms of contact with the justice system.
Well, there's a range of discretions exercised by people within the system, including the police. Is that correct?
That's correct.
And we have heard evidence, including from your secretary yesterday, about systemic racism within the system. And as we know, the exercise of discretion, particularly with respect to Aboriginal people, often is affected by people's bias and racism. Would you accept that that's a part of the environment that your division has to deal with?
As in that, a byproduct of that, the misapplication of discretion as a result of racism, we have to deal with the byproduct of that. I would say that's a fair proposition.
How much can your the youth justice division, that's not the correct term, is it?
Youth Justice Group.
Youth Justice Group influence the awareness and understanding of bias and racism within the other areas of government within which it deals?
I would say we don't have a formal capacity around the cultural awareness training for other parts of other agencies, including Victoria Police. That would be a matter for Victoria Police, but certainly the interactions that our staff have, and particularly our Aboriginal staff in those forums, whether it be the regional Aboriginal Justice Forums or the local care teams where there are interfaces with the court system or Victoria Police, our staff make it known the cultural factors which must be considered in putting supports around a young person.
And so, for the Commissioner's benefit, can you explain how it is that your staff are made aware and trained in terms of dealing with our Aboriginal community and their clients?
I might turn to Commissioner Davidson for that answer, if that's okay with you, Mr McAvoy.
So, Mr McAvoy, both our community and custody staff engage in mandatory cultural awareness training and material around understanding subconscious bias, and also sort of more broadly, obviously the issues impacting our Aboriginal young people and staff are certainly covered in that training. That training is delivered through an Aboriginal consultancy that specialises in cultural awareness training. So Tarina Fanning is the name of the trainer, and she's certainly well known for her success in terms of cultural awareness training, and understanding cultural bias is very much part of that training. In addition to that, our custodial staff under the Certificate 4 complete a national standard in a unit that's called Culturally Strong and Safe, and that sees them engaging in another day of mandatory training. And also, really importantly, the trauma-informed practice element of our training particularly looks at the impacts of intergenerational trauma, and understanding specifically in relation to Aboriginal young people and staff, cultural awareness around the impacts, but also the impacts in terms of how they may present, our young people may present within the system.
And that training, is it something that's completed once, or is there a mandatory refresher?
So there's not a refresher for that training, but what I would say is it's an ongoing process of learning, and I acknowledge the cultural load in many ways that is there for our staff, because our Aboriginal staff, because a very critical element of their role is building capability and understanding when it comes particularly to working with individual young people in the custodial space, and equally in community. Part of the training of our workers is understanding how to draw on the knowledge of those Aboriginal staff within ACOs, and working in a way that really integrates their knowledge and understanding of that individual young person, their unique cultural journey, their unique story in the work that they do.
Mr Davidson, the formal training, how long is that?
So 2 days for our custodial staff. It's not two days in a row though. What we do is, as our base level training for custody and community, we provide that base level training, then our custodial staff actually have to come back and re-engage in that training within that further day of training within 12 months.
Do you have good uptake of that? And do you collect data on the uptake?
We do collect data on the uptake, and I'd be very happy to provide that to the Commission. I don't have it on hand at the present time.
Has there been any consideration of making mandatory refresher courses?
I think it's something we certainly should look at and consider. I know we have had discussions with our Aboriginal team on the ground within our custodial facilities around that, and it's certainly something, as I say, that's part of ongoing discussions and at that individual care team level as well.
Mr McAvoy, the other thing that I would just add, just from the hearing other evidence from other witnesses in relation to cultural awareness training, where there is a training of workforce, particularly we have had conversations since some comments made by Commissioner Walter in relation to evaluation of that cultural awareness training, and an absolute need for us to ensure that there is a rigorous evaluation framework or process around cultural awareness training. So that is something that we will take away from these hearings, from this block of hearings that we've already kind of identified as wanting in youth justice. So we heard that loud and clear in other evidence as well.
And in terms, Commissioner, you've given some evidence about, as I understood it just a moment ago, about the role that Aboriginal staff or custodial staff have in on-the-job training, so to speak, for other staff. Is that, did you say something to that effect?
I think you have to be very cautious, and I certainly am very cautious in terms of saying their role in training. I think their role is a role that's always focused around building capability and understanding, but we very much acknowledge the cultural load that can come with that, and so we certainly don't place the onus upon Aboriginal liaison staff to be responsible for training youth justice
It's
staff.
not the case that you pay them penalty rates for having to educate people every day, is it?
No, Mr McAvoy.
But can I ask you this? What's the ratio of Indigenous custodial officers to non-Indigenous custodial officers?
So in the youth justice system at present, we have 4 Aboriginal liaison officers. That will expand out to 6 Aboriginal liaison officers. Then we have a team leader that supervises and supports that team in the work that they do, and in turn a manager that supports the team as well, and also feeds in really importantly into our custodial and broader executive and youth justice.
What's the role of the Aboriginal liaison officer? Can you just briefly describe their responsibilities?
Yep, absolutely. So I think the absolute key to the Aboriginal liaison officer role is they are the staff that are walking alongside our Aboriginal young people from the moment that they enter our custodial system. So at the point that a young person is brought to Parkville by police, our Aboriginal liaison officer team, no matter what time of day or night it is, are alerted to that admission. And from that point, it is their role to walk alongside young people to particularly ensure that their cultural needs are being met insofar as they can be within that custodial environment while they are dislocated from family, community and alike. And particularly important role in terms of ensuring that connection is maintained as much as possible, ensuring that young people are able to access cultural education and are also able to access their Aboriginal peers for support, and then also working alongside our educational providers, our care teams, our custodial staff to respond to the day-to-day needs of Aboriginal young person. And Aboriginal young people, they're also a really, really critical part of those care teams that sit around Aboriginal young people when they're in custody and are really focused on transitioning them out from the moment that they come into our facilities.
There's only 4 of them.
There's 4 of them at the moment. It will be expanded to 6.
What is the proportion of non-Aboriginal staff within these facilities?
So we do have some, I should say, do also have some custodial staff that are Aboriginal, and we very, very much support those staff in a similar way to what we do Aboriginal liaison officers in terms of appreciating the cultural load and providing them with that support. Just in terms of the ratios, and I do appreciate that you're looking at a broader ratio, which I don't have at hand, but I'm certainly happy to get, that at the present time, for example, we have 11 young people in custody, 11 Aboriginal young people in custody. So whilst the ratio overall to our custodial staff, I appreciate may be relatively low, those 4 staff are very, very actively working on the ground with those young people, and their aim is to ensure that every young person in custody is able to access an Aboriginal liaison officer at any time that they certainly want to, and that is what we drive towards, is that we're able to be as responsive as we possibly can to the needs of those Aboriginal young people through those staff.
You could provide that data on the actual ratios.
Yes.
That would be good, thanks.
I just want to move in a slightly different direction now in terms of research and monitoring of your own systems. I haven't been able to locate, but there may exist some longitudinal studies setting out the impacts of youth detention on young people as they mature into adulthood and beyond. I asked this question in the context that the Commission has heard evidence from Auntie Geraldine Atkinson about a nephew who ended up going through the youth justice system and dying at a very young age, 36. And it was her observation that contact with the system dramatically affects Aboriginal people's trajectory in life. And can you tell the commissioners whether that research is being undertaken by the Commission at this stage?
What I would say, Mr McAvoy, is I know the evidence is very clear on the impacts or potential impacts of incarceration on young people, and I absolutely acknowledge that research, and it is very clear to us, and we acknowledge the potential deleterious impacts of any contact with the youth justice system, but particularly custodial or incarceration, which sees young people dislocated from their families and communities.
It's not just the dislocation from family and community, it's also the new company that young people meet whilst they're in custody, and the adoption of different lifestyles, potentially.
Absolutely. There is a raft of factors that can contribute to the impacts of incarceration.
So in answer to my question, there's not longitudinal studies, but there's a ready acceptance that incarceration has a very dramatic effect on the life expectancy and trajectory for young people who come through the system.
Yeah, Mr McAvoy, it'd be from a Victorian context of, again, just referring to the work undertaken by former Commissioner Giacomos in the Task Force 1000 review. I was involved in a limited capacity in some of that work. And a case file analysis of those 1,000 young people that were in out-of-home care that had also contact with youth justice. Quite often their parents were in contact with the adult justice system, had previously been either child protection kids or kids in youth justice. So you see a very clear trajectory and that cycle through some of that work.
Thank you. Now, you've given some evidence about the numbers of young people presently in custody, but that doesn't represent the total throughput of number of young people over the course of a year, for instance, where you've got people in custody for short stays as a result of having bail refused. That's correct?
So there, as Commissioner Davidson said, there are currently 11 young Aboriginal people in custody today. 9 of those are on remand and 2 are on sentence. The period of remand varies, and quite often it's a shorter period for those on remand. And we absolutely acknowledge that any contact with the youth justice system, let alone custody, is a problem. And absolutely the caucus advocate quite strongly about that as well. So there are a number of initiatives that we have undertaken to address that issue, including, so for example, to your point about those short periods of remand, access to bail on a weekend when court isn't sitting. Quite what we found was young people would be picked up on a Friday night and remanded to the next available court, which is Monday. So they're spending a weekend on remand, which is absolutely unacceptable. So in partnership with the Children's Court, we've established the Weekend Online Remand Court. So it is an online court. The Children's Court sits. Youth Justice supports the young person alongside their legal representative to ensure that they have suitable representation and access to a bail application on the weekend so that they're not spending unnecessary time on remand. Youth Justice has also just taken on responsibility for the after-hours bail service from the Department of Families, Fairness and Housing, and we are re-enlivening or bolstering that system, that service, so that there is greater access to after-hours bail.
Thank you. Now, the Commission has heard evidence from a number of witnesses about the use of the criminal justice system for minor matters involving kids in care, children in their care placements, and the effect that that has on those children. Is that, you were nodding your head, Commissioner Davidson, is something of which you're aware?
Yes, certainly, Mr McAvoy, and we do acknowledge the particularly difficult trajectory for what's commonly referred to crossover kids, so young people that are involved in the child protection system as well as youth justice. It's an issue that we do deal with every day, and we do acknowledge that there is a particular overrepresentation amongst our Aboriginal crossover kids. So for the year 2021, for example, Victoria had the overall lowest rate of 10 to 17-year-old crossover kids. However, very sadly, we had the highest proportion of Aboriginal crossover kids. So we absolutely acknowledge that problem.
And in terms of the way in which youth justice deals with offending by young people in facilities, knowing what you know about youth brain development, what policies exist in or practices exist in respect of minor offending by young people in youth detention?
So the lens I would say that we take is that when we're considering behaviour in custody, we try as much as we possibly can to look at through the lens of a home-like environment. So where a young person becomes distressed and may act out in a particular way, particularly where they may act out on the environment around them, we take that through a lens of challenging behaviour, and we particularly involve our behaviour support team in youth justice in working with the Aboriginal liaison officers and others where it's an Aboriginal young person to try and address and focus on the behaviours and what has led to those behaviours, rather than focusing on taking charges against a young person. So we do have an incident management framework through which we manage those. However, where offences occur in custody against the person, so where those offences do occur, for example, behaviour projected towards our staff, violent incidents towards our staff or young people, we do refer those matters to police.
Now,
Can I just ask, how many incidents were there last year that were referred to police?
I would have to check that data for you. I'm very happy to get that though.
Can I just ask, sorry, Mr McAvoy, if you're referring that to police, could that be more charges whilst they're in custody?
Indeed it could.
And being of the age they are, is that under the care of the state? So who's the parent in those, particularly that age group? So who's the
So
parent?
if they are with child protection, then child protection would be viewed as the guardian.
In which case the Secretary of the Department of Families, Fairness and Housing would be the parent.
And so if they're not in child protection, what then?
So they're
I understood from the evidence yesterday from the Secretary that the Secretary is is in the position of the parent, the person in care and control of people in custody. Is that correct?
So my understanding is, and certainly happy to check the fact on this, but my understanding is that their parents are still remaining their legal guardians. However, they are under obviously the care of the Secretary whilst they are within our facilities. So for example, if a young person needs to undergo a medical procedure in the same way as we would be seeking parental consent. Those same rules in practicality apply, and certainly when a young person comes into our facilities, we maintain contact with parents so that where, for example, incidents occur, that parents are made aware of those incidents and those behaviours.
I think by going to the medical, of course you want to meet their medical needs, and I hope you would, Commissioner, I really hope you would. But you're also saying they're in your custody if they're locked up, and then you're still referring them to police. So
I think the challenge for us, Commissioner Hunter, comes from the fact that where young people are in our facilities, if they are engaging in, as I say, particularly violent behaviour towards others, that is a matter under law that we have to continue to take very seriously, and it does proceed down a criminal justice line.
And in practice, how it works, the framework to which Commissioner Davidson spoke to. So, for example, I think Mr. Karkas from the Career Youth Council in her evidence gave evidence around a young person in a out-of-home care placement or in a, what's it called, secure welfare placement, committing property damage, and then police being called around that incident. In youth justice, we wouldn't involve police where it's a property damage incident. Through the framework that Commissioner Davidson referred to, we would de-escalate the situation, have behaviour supports in place, and then talk through, once the young person is, once the situation has been de-escalated, then talk to that young person and work through a process of talking about and rectifying the behaviours. Where it is a serious assault, for example, on a staff member or another young person, that's that obligation around calling the police. That's the sort of distinction in how the framework works. So it's like it's I think the practice is different in youth justice than it is in the evidence that you heard about.
While I don't have an example to draw to your attention, it's safe to assume that just as happens in adult facilities, that there are some people who end up serving terms of incarceration for offences committed whilst in detention, which are much longer than their original sentence.
I would say that that can occur, yes.
Sorry, just to illustrate that point, Mr. McAvoy, the slide deck that we provided at the beginning of the hearing, I think on slide 2, there are some statistics on time spent on orders and return rates, remand. That might illustrate your point around time on remand being released being longer than a sentence in custodial sentence imposed. It's absolutely the case.
Is it fair to assume that the young people who are in custody are there in relation to what might be called serious offences?
I'd say it's fair to say they are they're in relation to more serious offences or a serious number of cumulative offences.
Is the number of young people in detention in Victoria in any way able to be correlated with the level of offending generally in the community?
We might have to look at that information would exist. I don't have it off the top of my head, but the Crime Statistics Agency would compile that data. I can't remember it off the top of my head, sorry, Mr. McAvoy, but we can get that. I seem to remember there is some correlation between the offending rates generally and Aboriginal youth offending rates, but I I can't remember specifically.
Do you have anything to add, Commissioner Davidson?
I think that is absolutely a question that we should take on notice and get that data from the Crime Statistics Agency.
Thank you.
Mr. McAvoy, can I just go back to your former question about remand? Sorry, I found the stat that was on that slide deck that I wanted to illustrate that goes to your point and your proposition. So 88% of episodes of remand were attributed to Aboriginal children and young people being released with no custodial sentence.
Yes. And just as the Secretary gave evidence yesterday, that figure is an unsatisfactory figure, you'd agree?
Yes.
I would agree, absolutely.
And it demonstrates that it raises the possibility that young people are either not being convicted and released without sentence, or are pleading guilty for the purpose of getting released because their conviction will not result in any additional time. Is that possible on those figures, or is it more that people are being released without any sentence at all?
We'd have to check and come back to you on that.
The other thing that we can say is that the vast majority of young people who do come into custody, Aboriginal young people that come into custody, are with us for 1 month or less. And as a subset of that, we know that 30% of Aboriginal young people who are with us are actually with us for 1 week or less. So quite brief stays, yet very impactful.
Which does raise the question of why you're putting them there in the first place.
Nodding your head, Commissioner Davidson, are you agreeing that that's the proper question?
I do appreciate that any period of time for a young person spent in custody, I deeply appreciate the potential impacts of that.
Going in for a week, it does seem to be very harsh. Something that is obviously, they're not considered needing to be incarcerated before that week or after that week.
I agree with your point, Commissioner Walter.
It also raises the question of the ability of youth justice to make use of the time that the young person is with them to figure out what assistance they need. Is there anything you can tell the commissioners in relation to the assessments that are undertaken when a young person comes into custody in terms of their health or mental health needs?
Certainly. So when any child or young person comes into custody, they are screened for health, general health and wellbeing, mental health needs within, I think it's 24 hours, but for Aboriginal children and young people, it's within 12 hours. A health screen, mental health, drug and alcohol assessments are done, and that goes into the information attained from that goes into our planning for what treatments or supports they might need while they're in our care.
Are young people assessed for FASD or neurocognitive deficiencies?
They can be. They are not specifically within that primary assessment phase, but we have specialised services which, if there is during that point of triage, as I'll call it, if there are concerns raised, we then have the opportunity of specialist Aboriginal identified specialist disability advisor who's able to assist us to work through considerations such as FASD assessment, cognitive capability, and then also consider referrals to NDIS and etc.
And in terms of the frequency of those types of referrals, is there anything you can say as to how common it is that young people come in with those types of concerns?
Sadly common, Mr McAvoy, is what I would acknowledge. So we know we have a disproportionate number of young people more broadly, but Aboriginal young people specifically that come into youth justice that do have identified disabilities, or through their time with us, those disabilities may indeed be assessed during that time.
So are you able to put some sort of estimate as to the percentages?
I could get you the data on this, Mr McAvoy, but in 21-22, Aboriginal young people, there were, in the community setting, there were 67.9% of Aboriginal young people under our supervision in community with a intellectual disability. That rate increases to 70.6% of Aboriginal young people in custody over that time period. So it's intellectual disability is quite a high. Language disorder in custody, for example, close to 12% had a language disorder. 6% had autism spectrum disorder. And another 6% had fetal alcohol syndrome. That's just for that period, for 21-22, before custody.
The Cherry Hill facility is more directed towards being able to provide support for people with those complex needs, or not?
Yes. And Andrea, Commissioner Davidson can go more into the specifics of this, but Cherry Creek will move for healthcare. It moves to a public health model, and that will be provided by Barwon Health, which has a broad suite of health interventions for young people. As a requirement of commissioning that service, we required the public health provider to also partner with an Aboriginal health provider. So they have partnered with Wathaurong Aboriginal Cooperative, which has, again, a suite of Aboriginal specific, culturally safe health services that will be provided to our young people, to the young people that are in Cherry Creek. And we also have in-house clinicians and disability specialists in Cherry Creek, which are currently under recruitment, that Commissioner Davidson could talk to in more depth around that model.
Just before we go to that, those, just to be clear, those services, it's not the case that those services couldn't have been made available in the existing facilities. It wasn't necessary to build Cherry Creek in order to provide those facilities to young people, was it?
So Cherry Creek, as part of the build, has dedicated mental health beds. So at the moment, in the other facilities, we have access to mental health beds that are provided by Origin. I just need to check whether that's the provider there.
Origin Youth Health, yeah.
Yeah, Origin Youth Health. So they're run by an external for Cherry Creek. Those mental health beds are in-house.
Did you want to add anything, Commissioner Davidson, to Mr Smith's answer in relation to...
Those services still could be provided in the current sort of settings, in a sense. I don't think we need to establish a new facility for young people to get access to these intense services. I think, just going back to the question.
I agree with you, Commissioner Lovett. And what I would say is, as well, under Wakara Gulpa, one of the commitments that our colleagues in Justice Health are working through now is the establishment, working in very close partnership with the Collaborative Working Group and Caucus, is the Aboriginal Youth Health and Wellbeing Strategy, which will sit across all of our facilities. I also think Cherry Creek is a point for emphasis and expansion. The mental health beds, for example, young people in the system are absolutely able to get mental health care at the present time, but what we feel is that at the present time a young person has to be in an acute state to be taken to a residential facility, so removed from that custodial environment and taken to the youth facility at Footscray Hospital. By having in-house mental health beds, that will allow us, wherever a young person is in the system, to be able to bring them to Cherry Creek and to be able to get in early when we're seeing those mental health concerns, which we're hopeful will mean that we see less need to have to take them for off-site services and then reintegrate them back into the custodial environment. So it's really about trying to get in earlier around those mental health concerns and ensure that we're really able to comprehensively as a system have that dedicated facility for those young people to go.
Seems to be advocating for the model in here, but earlier you were deflecting the earlier questions to, it was a government decision. So I just want to make that comment.
I meant just to ensure that when I say that, I mean the configuration of the system ongoingly. Yeah.
Would you say that most or nearly all of the children, Aboriginal or not, that they would need some form of mental health coming into the system?
Absolutely, and that is provided. So young people at the moment, Origin Youth Health does provide our mental health services. Primary mental health provided at that front end by CCA, but where young people have more significant mental health issues, Origin Youth Health is engaging them in our services, in our facilities currently.
Would you say most kids that come in have significant mental health issues?
I would say that most young people that come in have mental health issues, yes.
So those services should already...
They are available in our current facilities. The additional service that's available at Cherry Creek is a standalone mental health unit at the present time, and often it's the preferable option for young people to receive that mental health treatment as they do in the community within the unit that they are residing in within custody. However, there are occasions where we feel that having dedicated mental health beds will allow us a step before the need to go to acute care.
I just want to make a comment about, and we would hate to see that our people engaging in the justice system to be able to get access to these services.
I just want to take you back to the figures that you quoted from 2021, 22, I think was
2020.
No, 21, 22, an intellectual disability, those statistics,
Yes.
yeah.
So I understand that you told the Commission that there was approximately 70%. Is that the correct figure?
In custody, yeah, 70.6% had it.
70.6% of the young people in custody. And is that Aboriginal young people or
Young people had an intellectual disability.
have an intellectual disability? So by intellectual disability, that takes in FASD and early childhood trauma and other trauma-related neurocognitive type disability?
Yeah. The other thing I would say is that in relation to mental health as a separate from intellectual disability, there are, to go to Commissioner Hunter's question around the proportion of Aboriginal young people with an active mental health diagnosis, around 45% have an active mental health diagnosis, and the common diagnosis, the most common diagnoses are things around anxiety disorders, trauma and stress related disorders, and depressive orders. So they're also picked up through the system as well.
So if I can just, sorry for cutting you off, there's approximately 45% of young Aboriginal people who present into the custodial system have a mental health issue of some type.
A diagnosis.
Diagnosis of a mental health problem, and Commissioner Hunter was asking questions about significant mental health problems, and I noticed, Commissioner Davidson, that you were, I think, not characterising your observations around significant mental health, but talking about acute mental health episodes and more generalised mental health conditions. Now, assuming that we've got a 45% cohort of the cohort have a mental health issue and 70% have some form of intellectual disability, it raises the question fairly and squarely as to whether these young people ought to be in a youth justice facility at all, and whether they are more appropriately dealt with in a health setting. Would you agree with that?
I think that's a fair question, yes. And I think, just to expand on that point, Mr McAvoy, you might look to the contribution those conditions make to the offending behaviour in the first place, and if they were addressed in some other way, would it lead to offending? I think that's a fair line to follow.
What it says is that society deals with young people with health problems by use of the blunt instrument of criminal justice. Would you agree with that?
I think there are a high proportion of Aboriginal kids that are dealt with in that way, that they enter, they do not get the supports that they require in community, and then the trajectory, sadly, is into the youth justice system, and it's not where they should be.
And the health conditions that these young people present with are complex. Is that fair
Agree.
Inherently.
simplification?
Accept that.
And how then does a detention facility that is holding people for an average of 4 weeks deal with complex mental health and intellectual disability issues?
Is a very good question, and I think that's where, once a young person comes into custody, our focus is on transitioning them out and how we deal with those complexities once they're transitioned out, to ensure that we're giving as much room as possible for them to not be returning to us.
And so, as you've said before, there's strategies. I think you said strategies or a strategic approach involving the health organisations, but it seems to be fairly clear from your evidence that that some of these young people will need significant health support upon their release. Is that? Are you able to assure them or the commissioners that they get that support on their release?
So what I am able to assure the commissioners is that the care team process and the reintegration process is focused on the whole child and looks very much in detail at their individual risks and needs, and that health is front and centre of the considerations around those risks and needs, and what transition supports are required to ensure that young people are able to have those needs met. So from a youth justice perspective, that may be things such as the Aboriginal Youth Justice Program worker that may be sitting in a local ACO is walking alongside that young person to ensure that any of the barriers to access to services that they are able to work to break through. So for some of our young people, it's about when they arrive in custody, it can be the first time that they have access to that level of services, and it's ensuring that whatever barriers may have been there in community, to Mr Smith's point, can be addressed as part of that reintegration into community.
Can I just ask, when they're released, how do you ensure they're still going to engage? Like, do you work with the family as well, or is it just the child?
No, we work with the family as well, and many of our families are actually active parts of the care team, and in some cases, and certainly we encourage wherever young people feel safe and supported to be part of that care team themselves, to be able to articulate what those barriers are to them receiving those supports that they may not have received before they came into the youth justice system.
So what's the follow-up to make sure that this is happening post-release?
So that is through our case management framework and through those funding of those Aboriginal youth justice programs that maintain that continuity of care with young people. Yeah.
And then if there is reoffending and they end up back in the court system, do these reports be provided to the court so the court is making has an understanding of the offending behaviour, but also the individual.
Yes.
You're confident of that?
So where there's prior youth justice involvement and in the case management of a young person, whether it be an Aboriginal young person or not, youth justice will assist the court in its determination around the circumstances surrounding that young person.
And particularly their background and vulnerabilities.
But also youth justice will provide a recommendation to the court,
In relation to certain matters,
or in relation to offending behaviour, but also what the sentence, could look like.
I think particularly in relation to the nature of young people's engagement, supports, where they're at in the system, yes, and particularly when it comes to suitability for certain programs, yes, we do have a role there.
Yeah.
Following on from Commissioner Lovett's question, I'm not sure whether you've got the capacity to answer this, but do you know whether the assessments that are done in relation to intellectual capacity are made available to the young person's lawyer for the use in Dolly and Kapak's applications?
Certainly it's very common for that to occur. As to whether that occurs across the board, I'd have to check on that, but I know it is absolutely very, very common occurrence.
Sorry, I think I cut across one of the commissioners.
Yeah, I'm just thinking about child protection, a child that's in child protection and then criminal justice. They're two separate courts. Do they interact at all for these children? Is there any interaction?
I would have to check, but my view is that not in a formal sense. I think what we do know is that when a young person is coming before the court for a criminal matter, that where they are involved with child protection, the court is aware of that. And for the best part, it's my understanding that the court requires child protection to be there or to be able to represent their involvement with the young person through that process.
I worked in the courts for many years and I hardly any saw child protection practitioners turn up.
The other interface, Commissioner Hunter, that there is with child protection and youth justice is upon release, whether it's on bail or transitioning out on a sentence, is if that child is or young person is a child protection young person, they will be involved in the where they are released to, and so that's the other point, I guess, where youth justice works with child protection around. Okay, this kid's coming up, he or she's being released. Where are they going to? And that's another rub point with child protection.
So is, obvious, sometimes they probably wouldn't go back to the same carer or they wouldn't go to family.
That can be the case, yeah.
Yeah, so is there a risk of homelessness?
I think that generally speaking, the court wants to be assured, where the court is involved, particularly in bail, they will want to be assured that the young person has somewhere to go. What I would observe is that the stability of some of those placements, particularly where the young person has other vulnerabilities, particularly where they are a young person that's involved in child protection, that might be very short-lived. It might not be a particularly stable placement for them, and we've seen that.
You agree they're really complex kids in both of those areas?
Absolutely.
Do you think that there should be some treated differently in some respects due to the complexities of being in out-of-home care as well as being in the criminal justice system?
I think the level of complexity that those children and young people present with absolutely require a service that wraps around and meets the child where they are. And I'm not absolutely confident that that's done.
Thank you for your honesty. Thank you.
I noticed the time, Chair. I have a couple more questions, and I note that Commissioner Bell has some questions.
I don't.
I propose to ask the questions I have, and then perhaps we can adjourn for lunch. But given the material that has been requested from these witnesses, it will be my suggestion that they may be called back at some point for further evidence. I notice the witnesses are nodding that their willingness to come back at some stage, and perhaps, if not in this hearing block, in future hearing blocks. So the questions I have to ask are really probably more directed to you, Mr. Smith. Are you aware of research that suggests that for Aboriginal children with mental health or intellectual disability issues, that access to and participation in cultural knowledge and cultural activities is very beneficial to them?
I wouldn't be able to refer to any specific piece of research, but certainly what we've heard through our partners, such as Dadi Munmorrow, who we fund and partner with for some programs, that is absolutely critical in being more effective intervention for kids, young people that present with complex mental health
And
issues.
of the, you may not be able to answer this, of the children, young people that come into custody who have anxiety issues, do you know whether any of that, the anxiety is attached to identity matters for Aboriginal young people?
Look, I'm not sure whether any data exists on that. What I can speak to is some of the interaction I've had with young people, Aboriginal young people in particular, in custody. And I would say that knowing their identity or being embarrassed by their identity has been an issue that's been raised with me by those young people, and having conversations and talking through with them the strengths of their Aboriginality and what that brings to their identity is beneficial, and I've seen that firsthand.
And I take it that that is something that the facilities are aware of, and can you just, in a very short form, tell the commissioners how the cultural identity and participation in cultural businesses is provided for in the institutions?
So it is very centrally around our ALO team and ensuring that response, that cultural response, is individually tailored to young people where they're at. So it's really about wrapping our arms around Aboriginal young people when they come into custodial facilities, that team is really looking at their individual circumstances and how they can draw on the power of culture to be able to provide some strength for our young people during that time. So just as one example, one element of the work that our ALOs do when young people first come into custody is to talk to them about their connection to culture and to introduce to them certain cultural items that may support them and that they may be able to find some comfort in whilst they're in custody. So, for example, the wonderful possum skins that we see around here today, when Aboriginal young people come into custody, part of the discussions that ALOs have with them is around the use of a possum skin as a sensory item, and certainly having sat with Aboriginal young people in times of stress for them, I've seen them actively using and talk to them about how much strength they're able to draw from the introduction of those cultural items into their lives at that point in time. So that's just one example of how from the outset we're constantly thinking about how we can draw on the strength of culture to support Aboriginal young people.
And then access to elders is the other really powerful element, that in terms of particularly in custody. So at Parkville, through the Parkville College, Annie Joy Murphy, who's well known to this commission, I'm sure, the senior Wurundjeri elder, has, through the school council and her participation at Parkville College, Aboriginal young people have access to her, and that is a very moving, very powerful interaction. And sometimes it's the first interaction that some of the Aboriginal young people have with an elder, and that and we know that culture is a protective factor for these young people, and so we want to nurture that. And then in Malmesbury, Uncle Ron Murray, who I think we mentioned before, is our elder in residence that visits, and again the young men in Malmesbury take a lot from that interaction, in addition to some of the other programs, as I mentioned, Daddy Munro and others.
And finally, access to those cultural supports, that cultural education is affected by staff shortages, isn't it?
They can be, and we certainly endeavour wherever possible to ensure that they're not. And along with education, contact with and the ability for young people to exercise their culture regardless of their circumstances in custody is paramount for us.
But if an elder comes into a facility, they need to be escorted to where...
That's a good example, perhaps, Mr McAvoy, in terms of where the decisions that we make in custody will be oriented as much as possible towards a young person's well-being. So if we have an elder coming into the site, that will be absolutely prioritised for a young person to be able to see that elder.
Even if it's in lockdown.
Yeah.
Thank you. They're the questions of these witnesses on council assisting.
Look, I just wanted a final statement. It worries me that for the department to provide even a vaguely suitable service, ACOs and elders and others are being relied upon, and I just think it's such a burden, and I'm just wondering why the department can't provide that service. I mean, I think it's good that they're involved, but it seems that that's always the answer, that the department is incapable of providing what these young people need of itself.
I absolutely acknowledge the cultural load on our Aboriginal staff, and what I would say is that they are not the sole answer, and the progress that we've made in our case management framework on the whole, and a number of the reforms that have come in youth justice from Armitage and Ocklov, from the important work of Same Four Walls, Our Youth, Our Way, is really ensuring that we are, as a system, wrapping our arms around those young people. But I do acknowledge the cultural load on Aboriginal staff.
And then just to approach that question in a different way, Commissioner Walter, certainly what we hear from the Aboriginal Justice Caucus is that they don't want Aboriginal culture to be in the purview of the department, and that's a matter for community, but they should be resourced appropriately to do so. So we make our best endeavours to do that. And the other just element of that, through the work that I referred to earlier around the engagement we undertook with the caucus on development of a youth justice bill, they've said very clearly that that their aspiration down the track is that it is a Aboriginal-led and run youth justice system that's not run by the department. So it goes to those, to your point, I guess.
Commissioner Bell, are you okay for questions? Thank you, sir.
I have nothing arising from those questions.
I just have something to say. Firstly, I want to, even though it's low numbers still, I commend you on bringing them down. And I also wonder if that's you have Aboriginal leadership in this space. But I also commend you, because we didn't hear it yesterday, that you're taking on board the Aboriginal voices. But in also saying that, one kid locked up in a prison is one too many, particularly our kids. We know this. Happened through colonisation right up to now. Taking our kids and not supplying them with what they need, particularly when they're traumatised. We know this stuff. You know this stuff because of the Same Four Walls, Our Youth, Our Way, always was, always will be Koori children. You've also said you understand the impacts of intergenerational trauma, yet we've still got rolling lockdowns. We're still having kids locked up, and we still have staffing shortages. These are recommendations from 2017. It's really unacceptable, I think, knowing how traumatised our kids are, and we re-traumatise them. It's not acceptable, and you've both acknowledged that. We can't wait, yet putting money into a new facility is really contradictory and disappointing.
Thank you.
So this session is adjourned, and we're resuming at 2 o'clock for the next session. Counsel?
Yes, thank you, Commissioner.
Thank you. Thank you. Thank you. And thank you very much.
Thank you. Thank you.
Thank you, Chair. This afternoon's session, we are hearing evidence from Mr. Ryan Phillips and Commissioner Larissa Strong. There was a matter of housekeeping that we're attending to. It's not, but we'll deal with that perhaps a little bit later this afternoon. So, Commissioners, I call Ryan Phillips and Commissioner Larissa Strong. They're in the witness box. I understand that the appearances are the same as this morning. Mr. Knowles is appearing for both witnesses.
Yes, Commissioners, I appear with Ms Siobhan Kelly for the State of Victoria, and in particular for the witnesses that are giving evidence this afternoon.
Thank you. Thank you.
And as with this morning, I'm appearing with Mr. Boyd Kane.
Thank you.
I will swear the witnesses in if that's suitable, Chair. Mr. Phillips, could you tell the Commissioners your full name, please?
Ryan William Arthur Phillips.
And you're about to give evidence to this Yoorrook Justice Commission. Is the evidence that you'll give today, will that be the truth?
It will be.
Thank you. Commissioner Strong, could you tell the Commissioners your full name, please?
Larissa Jane Strong.
And will the evidence that you give today to this Commission be the truth?
Yes, it will be.
Thank you. I invite you, as we do with all witnesses of the government witnesses to this Commission, to make any opening statements you wish to make. Is there anything that you wish to say before we commence?
Yes, I would like to make an opening statement. First, I'd like to begin by acknowledging the traditional owners of the land on which we're meeting today, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders, past and present, and all Aboriginal people in the room today. I'd also like to acknowledge that sovereignty was never ceded, and the strength of the continuing connection of Aboriginal people to their land and culture throughout Victoria and the nation. I'm very grateful for the opportunity to give evidence today. I know that it's a privilege to be able to talk about our system, its failures, what we're seeking to do differently. And I wanted to acknowledge at the outset the Aboriginal people who passed in custody and the compounded pain and trauma that every passing causes Aboriginal people in the community, their families, and Aboriginal staff who work with us. I acknowledge that the correction system is a legacy of colonial structures that did damage and continue to do damage to Aboriginal people to this day. And I particularly acknowledge the 5 Aboriginal people who passed in custody since I commenced in the Deputy Secretary role for Corrections and Justice Services. Aboriginal people who were disconnected from their country, families and community. I also acknowledge Aboriginal people and members of the community who have family members in prison. We know that for many, having family members in custody is a deeply worrying and upsetting time. I've heard so many stories about that, and it's something that I don't take lightly in terms of the responsibility we have for the people in the custody of Corrections Victoria. I've heard clearly from the Aboriginal Justice Caucus and community, and also evidence presented here and in the cultural review into the correction system, that racism is endemic in the justice system and equally so in the correction system, and that we need to change. The truth of Aboriginal people's experience is a source of great shame and regret in terms of experience with our system, and I apologise for the ongoing impact and suffering of people in custody, as well as their families and communities. Finally, I'd like to acknowledge the Aboriginal people who work with and in our system, so the Aboriginal Justice Caucus and all of the Aboriginal organisations that we engage with regularly. Our many staff who work within a system that was not designed for them, but nonetheless are committed to working to achieve outcomes for their families and community. I know they carry a heavy burden and we need to do more to support them, but I look forward to talking to you more about that today. To you, Larissa.
Thank you.
I would like to acknowledge the traditional custodians of the land on which we're meeting, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past and present. I'd like to pay my respects to all Aboriginal people in the room. I'm here before the Commission humbly. I would like to acknowledge, because I have worked with Aboriginal Justice Caucus and Aboriginal staff for many years, and acknowledge their tireless efforts in improving our system. And I commit to this process and to telling the truth. Thank you.
Thank you.
Thank you. Now, Mr. Phillips, your position is as Deputy Secretary in Corrections and Justice Services within the Department of Justice and Community Safety?
That's right. I'm subject to one caveat. I'm currently acting as Associate Secretary.
And could you explain both the Deputy Secretary position and its remit for the Commissioners and also your acting role?
Yes. So I've been employed in the Department of Justice since May 2017 as a Deputy Secretary, but most recently as the Deputy Secretary for Corrections and Justice Services. So I commenced in that role in the second half of 2019. In the role I'm substantively employed in, I have responsibility for Corrections Victoria. With Larissa Strong reporting to me, I have responsibility for Justice Health, which provides health services to adults and young people in custody, and for Justice Services, which oversees the state's regional service delivery footprint. So that's most relevantly community corrections. I also have responsibility for key related policy functions in respect of those operational areas. As Associate Secretary, it's a role I've been asked to perform by the Secretary for 6 months. I continue to have responsibility for Corrections and Justice Services. I also have responsibility for the department's corporate functions, so that's finance, HR and the like. And I've also have Josh Smith, who you met earlier today, reporting to me. So I've been in that role for about 2 months.
Thank you. Now, could you also describe for the Commissioners your professional background and experience?
My professional background is as a lawyer, so I was legally trained. Before working at the Department of Justice, I was employed at the Department of Premier and Cabinet, where I performed a range of roles across social policy, governance and the legal branch, and included as General Counsel of the Department of Premier and Cabinet. Prior to that, I worked at the Kimberley Land Council in Broome for 2.5 years, so I have some direct service delivery experience of working for Aboriginal people in the Kimberley. And then prior to that, more junior legal roles in the private sector.
Thank you. Commissioner Strong, could you describe for the Commissioners your present role?
I'm Commissioner for Corrections Victoria. Corrections Victoria is responsible for the adult custodial system, running the public prisons and also oversight and monitoring of the private prisons and the programs and services in the adult system as well.
Thank you. And your professional background?
I'm a career public servant. I have arts degree. I'm not a lawyer. I commenced in the Department of Justice about 20 years ago, and I have been working primarily in the corrections portfolio for most of that time.
And it's correct that you were working in the justice portfolio prior to being appointed as Commissioner?
Oh, yes, I'm sorry. Yes, I was Deputy Commissioner for Corrections Victoria from around, I think, 2016. I started to act as Commissioner in mid-2020 and became appointed in ongoing capacity in early 2022.
Thank you. Now, just so that we're clear, Commissioner Strong, do you have up-to-date figures on the prisoner population in Victoria?
From Monday, yes, I do.
You could just share those with us, please.
On Monday, which I think was the 1st of May, we had 822 Aboriginal people in the adult custodial system, which represented, I just need to put my glasses on, sorry, which represented 12.5% of the prison population. Of those 822 Aboriginal men and women, 48% were unsentenced. On Monday, the breakdown was 783 Aboriginal men in the adult system, which was 13% of the total male population. And of those Aboriginal men, 49% were unsentenced. And on the 1st of May, in the system, we had 38 Aboriginal women, which comprised 12% of the total female population. And of those Aboriginal women, 44% were unsentenced as of Monday.
And with respect to the male population, do those figures, as of the 1st of May, represent a decrease in numbers of Aboriginal inmates?
From when, sorry?
Over this present year?
I think it would be an increase over the 12-month period.
And with respect to the female population?
I would have to double check, but I think that would be a decrease from 12 months ago.
And over the period of the last decade, there's been a substantial increase in both men and women Aboriginal prisoner populations. That's correct?
That's correct, yes.
And that has increased at a rate higher than the general prison population. That's correct?
That's correct, yes.
And in particular, there's been an increase in both the men and women's prison population with respect to the percentage of unsentenced prisoners.
That is correct as well.
And this issue of the increase in the unsentenced population was covered in some detail in the inquest and the coronial report into the death of Veronica Nelson.
Yes, it was.
And you're aware that that report was highly critical of the 2018 amendments to the Victorian Bail Act.
Yes, I am.
You're aware that there have been some announcements about proposed reforms to the Bail Act in response to that coronial inquest?
Yes, I am aware.
Have you had a chance to consider how those reforms might affect the numbers coming into the prison population?
Yes, we have. So there is an area within the Department of Justice that does modelling, if you like, on impact in terms of numbers. So that is a different area, but obviously we were consulted on their modelling in terms of what that might mean in terms of prisoner numbers, and also translation to prisoner beds as well.
And that modelling is important to management of facilities and prisoner numbers and staff, and is that the case?
It's important, I guess, in terms of advice to government about the decisions and the decisions that they make so that they understand what those decisions mean, and also then how we address and take appropriate action.
So, I mean, I would, can the commissioners assume that that sort of information is also useful in determining whether the new facilities need to be built?
That is correct. So exactly the same scenario, whether there was a proposal about changing legislation which maybe made legislation more strict, for want of a better word, the same process would be underway by the modelling people in terms of what that meant. And it is a projection, it's a forecast, it's obviously not a complete science, it's a forecast, but absolutely that work is done.
So can you share with the commissioners what the forecast is in respect of the last announcement in terms of a reform to the Bail Act?
I would have to take that on notice. I don't know off the top of my head the forecast of those numbers, but we can get them to the
Do you know in general terms what the projected effect will be?
No, I'm sorry, I don't.
So you can't say here today that you've been informed that it is likely to bring about a decrease in numbers of unsentenced.
I can say that. That is certainly, it will bring down a decrease in the number of people coming into the system unsentenced, a decrease in the number of people in prison who are unsentenced. That is true, but I guess the volume of by how much is something that I don't know to tell you right now.
And we heard evidence this morning that there were proposed to be constructed some new facilities in Victoria?
Yes, that's correct.
Corrections facilities. Can you just tell the commissioners how many facilities are proposed and where they're at?
So there was a decision taken some years ago. It predates COVID, and it was at a time when we did have a significant increase, and historical increase in the prison population. And a new prison called Western Plains Correctional Centre was a decision to build that prison in response to those increasing numbers. That prison has now been built, but it's not operating. We don't have money to operate that prison because our demand has dropped, so we don't need to use those beds. But the decision was taken
How much money did it
along. I'm trying to. Sorry.
Sure.
It takes maybe about 4 years, so I guess the decision might have been taken about 5 years ago. I would have to confirm that. And the prison got handed over to corrections to maintain its integrity towards the end of last year.
Was there a correlation between the bail reforms and the decision to build that prison? Things are around about the same time period?
The decision was very much based on the fact that we had an increase in prison population and increasing prison population of remandees. So, yes.
Commissioner, have you been involved in the proposed amendments to the Bail Act?
No, I haven't.
You haven't been asked what the impact of changes might be on population numbers in prisons?
Corrections has been asked about what the modelling that the Crime Statistical Agency has done in terms of numbers would mean in terms of translation to beds. So yes, we have been asked about that. So not every person diverted translates to a whole bed because the whole bed's 360 days. So that's where we've contributed to that impact in terms of bed population.
Can I ask how much it cost to build that prison?
Around 1 billion, 1.1 billion is capital cost.
Sorry, Commissioner Lovett, I didn't quite hear the question.
How much did it cost to build that prison?
And the answer was around 1 billion.
1.1 billion around, yeah.
And it's yet to be commissioned.
Correct. It does not have operational funding to take any men into it.
You made a comment before about maintaining its integrity, I think it was. What is the cost of that as it's sitting idle?
I think we got funding, I might need to double check, but I think it's around $36 million. It's a very large footprint. It has a number of security features. We need someone to be able to respond to alarms such as fire alarms, to make sure even things like showers and the water membrane doesn't crack. So we do need a small staffing contingent so that that facility is maintained.
You don't have a problem with people breaking into it, though, I don't suppose?
Well, no, but one of the things about the integrity is you do want to know that someone hasn't broken into it and built a tunnel should you ever want to use it into the future. So,
is it the case that it may come into operation as other facilities reach the end of their useful life, or is that being discussed?
certainly, yes. So certainly, I guess, options around which we'll need to, what are your numbers? What are your projections of your numbers? What is the state of your existing facilities? Options to close old infrastructure. Absolutely. Our discussions that have taken place.
I take it it's a government-owned and run facility. It's not a private.
Yes, it's a public prison. Yes.
So at the moment, the expectation is that perhaps the prison population will level out for a period. Is that?
At the moment, traditionally our forecasting has been quite reliable. The impact, I guess, of COVID-related pandemics really had a disruption to criminal justice activity and to court activity, which then flowed on to our prisoner numbers. We are obviously getting out of COVID restrictions, but it's probably a little bit too soon from a trend perspective for our projections to be quite as reliable as they used to be. We have had it's pretty level at the moment, actually, our numbers, in terms of the last 12 months. They have not been, they've been quite level. So we had a dramatic drop during the COVID-related pandemic. When we started to get out of lockdown, our numbers did go up a little bit, but they are quite level at the moment.
I'm sorry, you might have answered this already. The Western Plains facility, was that intended to be a remand facility or a mixed facility? Or
Mostly remand.
Now, I've got some questions for you, Mr. Phillips. There was a strategy within government in terms of reducing prison population, labelled the demand reduction targets, DRTs.
The reducing reoffending and keeping people out of prison, otherwise known as a rock pop strategy.
That's the current one?
That's the current one, yes.
But prior to that, was there the use of a strategic target system called demand reduction targets? Do you have that?
I think the demand reduction targets were embedded in the rock pop strategy.
Right.
One of the elements of that.
And so are they still then relevant?
They are. So to be clear, the responsibility for that strategy, it was led by a different part of the department, so I didn't lead that. We were consulted in its, I was consulted in its development, but that certainly wasn't something that sat within
Which part of the department had the responsibility for rock pops?
I was in the former secretary's office.
Can I just ask you to elaborate on the word you were consulted? Was it just a phone call or an email? Thank you.
So the teams, so there was a strategy team that sat within the former secretary's office, and that team was responsible for undertaking a lot of the strategic policy thinking and advice to government. I have a corrections policy team that reports to me. Our teams, the Rock Pop strategy team and the corrections policy team worked together at officer level to make sure we were comfortable with the strategy that was being developed and actual information, input, etc. to support the development.
It's quite a depth of knowledge about it. It wasn't just an email.
No.
Yeah.
No.
Okay. I just want to clarify that. Thank you. Sorry, Jamie.
And just for the record, the rock pops is a reference to a strategy which is named Reduce Offending and Keep People Out of Prison Strategy. That's correct?
That's right.
Do you now have within your area of operation any role with respect to the programs or the ongoing strategies around the rock pops?
The reason I'm pausing is I believe that there was some government funding for particular initiatives under the Rock Pop strategy, and I'd need to follow that up to take that on notice about which programs were funded. Larissa may be able to talk in more detail.
We do have programs that we are delivering under that strategy within Corrections Victoria, and Ryan's correct, we got funding for some of those programs. So one was the Maribyrnong Community Residential Facility, which is a secure and stable, I should say sustainable, safe housing for people, for men exiting the prison system. We also got funding for a disability service across the prison system, a prison disability support initiative. And we got funding for some pre and post-release services for people exiting prison either on remand or after a very short period in custody through that program.
And was there any funding or work in relation to the provision of high-risk beds in relation to perhaps managing bed shortages?
In relation to that particular strategy?
Yeah, that came from the Rock Pops strategy.
I don't believe so.
Okay.
No.
I don't think so. But
does it still have? Is there still funding coming from that strategy to the operation of facilities?
those programs, yes, are still existing and have funding.
But that's not the only source of program funding for operation facilities?
That's right. So, yes, correct.
And so can you just assist by telling us what other sources of funding there are for programs?
So our base budget, we would fund a lot of our programs out of our base budget, ones that are delivered either internally and some that are delivered by other agencies that we fund to provide those services. And there are other programs that we would get new initiative funding through the budget process as well. So we probably have two main sources. It's either in our base funding or it's a new budget decision and it's a new initiative funding component. And I'm not sure, your question was on the programs that are funded through that. So we have an internal group of clinicians, psychologists, forensic intervention services who deliver offending behaviour programs, so there's sex offender programs and violent intervention programs. They're our employees, that's funded through our base component of funding. We have reintegration programs, so for people to support their transition from leaving custody back into the community. We tend to fund non-government agencies to deliver those programs.
Are there any Aboriginal specific programs that are funded from those?
For reintegration in the women's system, Drummond Street have an agreement with Elizabeth Morgan House to support the women, the Aboriginal women exiting the women's system. Elizabeth Morgan House is an Aboriginal community controlled organisation. We also do fund Yoorrook, which is again, it's transitional housing, up to 6 units. A Victorian Aboriginal Legal Service provide the services and the case management support for that service, and that's for Aboriginal women. We fund family violence.
Sorry, just on that program, is that a program that's subject to recurrent funding, or is it on a?
It's fixed term funding. We fund, the other programs that we have available are some family violence programs, and we also do have programs in cultural programs as well for Aboriginal men and women in custody, which are primarily delivered through Aboriginal organisations with support of our own staff, Aboriginal Wellbeing Officers.
Can I just ask on that, Council, if I can, because we've heard internally directly from people that are incarcerated that they're only getting programs that are art. That's the only cultural program they're getting, so I'd like to hear.
We can certainly provide data on, I guess, the programs and program access. So the different programs that we have, cultural programs, so one is The Torch. It does have a big uptake across the prison system, and that's an art program. TAFE also deliver art programs for Aboriginal people as well. We have a Kaka Wangiri Wangin Marie cultural strength and resilience program, and that has Jura, for example, through that program deliver dilly bags and I think it's called Sisters Day Out programs. There's a Maramali healing program through that grant program as well. We fund Wandama Prison to Work program. It's not a cultural program, it's more of an employment program but with a cultural lens aimed for Aboriginal people. I'm trying to remember.
That's all right. We can obviously come back to them later because I don't want to insult.
It's not a memory test in
Okay.
that.
No.
But certainly the Aboriginal specific programs are matters of particular importance to this Commission, as you understand.
Yes.
One of the programs that might exist, which we are aware that exists, but is not one for the prisoners, it's cultural awareness training for the staff. And that comes out of your base funding, does it?
Yes, that does.
And is it mandatory for all staff to undertake cultural awareness training?
It's mandatory for all prison officers.
Or prison officers, correctional officers?
Yes.
And you're aware, aren't you, of some difficulties with delivery of that program at Dame Phillips Frost Centre?
I am aware of there's two things. So one is the cultural awareness training that all new prison officers must do as part of their pre-service training before they become a prison officer. That's delivered by the Koori Heritage Trust. The Dame Phillips Frost Centre was additional training for all staff at Dame Phillips Frost Centre, so for all custodial staff, whether they were senior prison officers, operations managers, and all VPS staff that work at Dame Phillips Frost Centre. It's delivered by NJAC. It's a new initiative. We only started delivering that training on the 28th of February. We've had 4 sessions to date, and it's deeper than the cultural awareness training. We've had around 80 plus staff so far go through, but we will have 500 staff go through that training. And it's partly to support a new Aboriginal healing unit at Dame Phillips Frost Centre that's due to get up and running in mid this year, and to support the Aboriginal controlled organisation that will deliver the programs and services in that unit. So to provide a better environment, we have NJAC providing this training to all staff at DPFC. There was an issue last week in a training session where one staff member did leave the room. Someone went to check on them and they did say they weren't going to come back. So most of the evaluations have been very positive. So 90% of the staff who to date have done the training have found it really positive. We've had some staff that have found it very confronting, but I think they're the discussions we need to have. You know, it really does go into the terrible history of colonisation and the impact on Aboriginal people. And we've had a small number of staff who have queried why they should be doing this training, which we will be absolutely managing and taking seriously. We're making some changes. We're going to take the training off-site, non-uniform, and extend the time of the training so people have more time to reflect and to discuss that and to process the information and what it means for them in how they work.
How long's the training now?
It will go to 4 hours. We did compress it to 2.
2 hours?
The reason it was compressed to 2 is we didn't want to have women locked down to do the training. So we're going to go back to 4 and rearrange rosters to support the training.
What about medical staff that you have on site?
Do you want?
Yep. I can talk about medical staff. So certainly, medical staff. There's significant changes that are coming in health service provision, and ahead of that, efforts are being made to improve cultural awareness training across. So, for example, in particular at Dame Phillips Frost Centre, there has been training provided to all of the health staff, noting that we will be moving to a new provider from 1 July. Embedding cultural awareness training across the health system is clearly critical. We know that the failures that we've been seeing in health service provision are at the heart of many of the deaths in custody. Unless we can change our workforce, we're not going to get a different outcome. So immediate action has been taken, but there's a longer term strategy now with new healthcare providers.
So will that be mandatory that they have to do this training?
Yes.
Thank you.
So can we take it from your answer in relation to the question around the training at Dame Phyllis Frost Centre, that it's something you're aware of and you have in hand?
Yeah, I was. I think it happened on Thursday. I was briefed on either Friday or Monday, and I am absolutely aware of it. There is a meeting on Tuesday, which my Deputy Commissioner is going to.
Just going back to the programs you were speaking of earlier, for the prisoners' benefit, are all of those programs available to unsentenced prisoners?
All of the cultural programs, yes. The only programs where you have to be legally cleared is the offending behaviour programs. Education, harm minimisation, cultural programs, reintegration, they are available. There are some practical reasons why you may not have access to those programs. Some people are in and out so quickly that, we do a language and literacy numeracy assessment, but normally that's about 3 weeks into being in the system. Some people are in and gone within that 3-week time frame, so they haven't gone through that process or engaged with TAFE at that point in time. But in terms of criteria, it's only the offending behaviour ones that you need to be sentenced for.
I think we've heard, given the overrepresentation of Aboriginal men and women in the corrections facilities, and you talked about cultural programs, we've heard directly from people in prisons saying that they are still having to wait to get a cultural program. That's sort of contrary to what you're just saying right now. Whether on remand or whether they're sentenced, they still, because the overrepresentation, there's so many people in there that there's only so many people who can attend a class, whether it be an art class or a dance class or anything.
Yeah. So I may have, not answered exactly. I was referring to what's technically eligible, and then there are barriers in terms of access. So one might be to do with the fact that people are in and out quite quickly. Another one might be to do with, that you've got more demand for the program and that's available, and you might have to wait to get that program. We certainly had issues, though we are out of that now in terms of COVID, and a lot of those programs moving to remote, which was not ideal at all. They are back face-to-face and have been for some time. When I looked at the data, and it's not unique individuals, but in the 6 months, so from July to December last year, we had 954 Aboriginal people had participated in one of those cultural programs. Now, some of those people might have done a number of them, so that's not a unique individual number, and that doesn't reflect, people who flow through the system. So while we might have 822 people on Monday, the people that will flow through our system is a much higher number. So absolutely take your point that people will have to wait for programs.
Given we know the data of the overrepresentation of our people, we I guess, would hope that the system would accommodate and know, you got forecasting data, as you were talking about earlier, and another element of this work, that Aboriginal people should have access to cultural programs.
Yes, I agree.
Thanks.
Just on that question of overall numbers, not daily bed numbers, but overall throughput over any given period, do you have that data available to you?
We do have that data. If you rely on my memory, it might not be reliable, but if I look at receptions in the last financial year, I think we might have had about 12,000 receptions and around 11,000 discharges, which is a term we use, so it sounds like hospital, but we mean releases. We would have that information available by Aboriginal men and women as well. I just do not know it off the top of my head.
And is it the case that the throughput numbers for Aboriginal detainees is higher than the regular population, again, reflecting a higher number of shorter stays?
Yes, I think that would be the case. Certainly our median stay is shorter for Aboriginal women and Aboriginal men compared to non-Aboriginal women and non-Aboriginal men.
Does that indicate that men and women going in there, especially on those remand, are on less serious charges?
I don't know if I could speak to that. It does indicate that probably you have, which we do know, that we have a higher proportion of Aboriginal people in custody on remand. And often the people on remand might go in, they might subsequently get bail and then be released.
Do you have data on the charges against all of these people so that we could actually look at the pattern?
We have records on everyone and on what their warrant and what they're in for. How we could extract that, we can take on notice how we could do that. Yeah.
Thank you.
Do you have a view as to the cause?
I think it's related to changes in the Bail Act, which has seen a higher number of people coming into custody on remand. I should say progressive changes starting from 2013, but then also the 2018 ones were significant.
And you talked about the intake assessment in terms of their certain capacities that the prisoners might have coming in. It is the case that you do medical assessments on intake?
Yes, so it's a requirement that everyone who comes into prison from either police cells or straight from court is seen by a doctor and a mental health nurse within the first 24 hours. And it normally happens, unless they're a very late reception, within the first. They come in, they put in a holding cell, they go through a system, we'll check that we've got a warrant, that they're the right person, they're legally detained, and then they'll move to see the doctor and the nurse through that process.
And you heard the evidence this morning with respect to young people, did you?
Yes, I did.
And the numbers of young people assessed in the system as having some mental health or intellectual disability?
Yes, I did.
Do those same figures flow through to the adult population?
We certainly have a much higher rate of people coming into custody with mental health issues and needs and with disability. If I look at, and it's not a mental health diagnosis, which is what Youth Justice were talking about, though I think that information would be available through Justice Health, but we do use ratings in the prison system, so we have a psych rating, and that helps us understand where they can be placed and their management. So we have, I think it's about 48 or 49% of people in the adult system who have a psych rating, which most of them, about 42%, it is a diagnosed, it's a mental health issue that's stable but requires support and treatment.
And do you have access to numbers of Aboriginal people within that cohort?
Yes, the Aboriginal people have, in terms, again, not the mental health diagnosis, but the P rating, a higher percentage of Aboriginal people would have a P rating in our system. It would be more around the 60% from memory.
60% of the cohort or 60% of the Aboriginal people?
The Aboriginal people.
60% of the Aboriginal people in the system come in with a psych rating, or have it?
Have one at, yes, not necessarily, yes, they have one.
I may be able to assist the Commission with some statistics. So from a health perspective, when I speak about the prison population generally, 1/3 of people coming into our custody have come into custody with a pre-existing mental health condition. In the same way, there is a much higher levels of mental health conditions for First Nations men and women. So the statistics I have are that 72% of First Nations men have a mental health condition on entry into custody, and 92% of First Nations women.
92%.
And so that's a condition that is present on intake.
That's right. The most common being depression, anxiety, so quite generalised mental health conditions being the dominant categories. We would be able to provide greater breakdown for you as well if that would be of assistance.
So, yes.
Yeah. Thanks.
Thank you. So when you layer those statistics on the overrepresentation of First Peoples in the system, you end up with a very high prevalence of Aboriginal people, First Nations people in the system with mental health problems as compared with the rest of the population.
That's right, yes.
Have you done that analysis?
We have, and there are the key response to that is the new approach to health service delivery, which comes into effect across Victoria's men's and women's system from 1 July. So this is the recommissioning of health services, which includes both physical health but also primary mental health, which so secondary, so more serious mental health is dealt with by forensic care, so a partner in the system, but the primary health service retendering seeks to focus on a number of priority cohorts, but Aboriginal people in custody being the key focus of our health reforms, given the significant mental and physical health challenges that we know Aboriginal people in our care face.
If we could just stick with the mental health challenges at the moment, I understand that if I understand it correctly, those people who are assessed as having a mental health issue are not at that stage acute, or does it include people who are having acute episodes?
That includes everybody, but a significant proportion of people will not be having an acute episode on
So not all of, sorry for cutting across you, not all of those people will require medical intervention? Is that the case, or they all do?
No, they don't necessarily. It's have they been diagnosed with a condition at some stage before entry, but they may enter into custody with medication for depression, and so then simply require continuation or maintenance of that once they are received into custody. But then there are other people who have much more acute. We know that many people who come into custody have not been able to access mental health care before they reach us. I think there was evidence presented to the Mental Health Royal Commission in Victoria about the fact that for many people, entry into custody is the first point at which they receive appropriate or any care.
Without the risk perhaps of sounding a little bit flippant about it, at times it must feel as though you're running a secure medical facility.
I think that there's some truth to that, and Larissa, you may be able to talk a bit about some of the facilities, the Marmac facility and other facilities in our system which seek to meet the needs of people with particularly acute mental health conditions.
I think it is a challenge in terms of the people that do come into our care who do have mental illness, and some of them have very serious mental illness. Our response to that has been to, when Ravenhall was built, we did invest in mental health beds delivered by Forensic Care, who is the state's statutory forensic mental health specialist, and we invested in 75 beds at Ravenhall to really acknowledging that we were struggling with how do we appropriately manage people with serious mental illness while they might be awaiting a bed at Thomas Embling Hospital, for example, for compulsory treatment. In the women's system, we have also a mental health unit also run by Forensic Care, which is 20 bed.
And so that 75-bed facility and the 20-bed women's facilities,
There are also at the Melbourne Assessment Prison, there's an acute assessment unit, which is a 16-bed, and at Port Phillip Prison, there's a 30-bed psychosocial unit.
Are those beds regularly full?
Yes, they would be.
So there is a perhaps further need within the system for more acute beds for mental health issues?
I think it's partly, yes, I think that's true, but it's also work with Department of Health about, I guess, beds in Thomas Embling for people who might be more appropriately managed at Thomas Embling as well. And also, I guess, the focus of the Royal Commission was acknowledging the need to really lift the specialist mental health services available for people with serious mental illness as well. So I think it's all of that.
And
Commissioner, you're giving me the impression that the system is handling under stress mental health demand, but it's much worse than that, isn't it? I was a judge, as you know, for 15 years. I've got direct experience of this. I was the president of the forensic lead panel for 4, rather 6. And my experience is that it's extremely difficult for prisoners to obtain the mental health treatment, care and support that they need. It's extremely difficult to access beds. And as for getting access to Thomas Embling Hospital, good luck with that.
Yes, and that's partly why I guess we had a Royal Commission into mental health. So yes.
but it's the case that the recommendations from that Royal Commission are still in the process of being implemented. It's not the case that they've all been met, is it?
That's my understanding.
We've also had evidence in the course of this mission from lawyers from VALS, the Victorian Aboriginal Legal Service, who made observations about the number of their clients who have mental health or substance issues being exceedingly high, and their concerns that people with health issues are being dealt with in the criminal justice system. You're on the tail end of that, running correction facilities. Is it fair to say that the demand is not diminishing but growing in terms of mental health services?
That's slightly difficult because our numbers have actually gone down because of the COVID pandemic. So, but within that, whilst we have vacant beds, which is a great thing, in our normal general beds, our mental health beds are full, which just indicates that there was unmet demand even before that.
And the numbers that you've given on people assessed at intake doesn't obviously include people who are diagnosed or develop mental health issues whilst in prison. There must be some cohort that falls into that category.
So I think Ryan's numbers on the Justice Health record were from intake. The numbers I provided were at any one point in time in the prison system. And they weren't a diagnosis, but more a flag for us to be aware of.
Thank you. Moving now to...
Well, can I just make a little statement about mental health? It's just struck me that you made that statement at the start that the criminal justice system is an ongoing legacy of colonisation, given that First Peoples suffer huge levels of intergenerational trauma, which much of the mental health experience is linked to that. Are the Aboriginal prison population in Victoria an ongoing legacy of colonisation as well?
Yes, absolutely.
Can I just add sorry, so we've heard directly, particularly from the women that have struck me, it stays with me, the things they've said. They're coming in already diagnosed, but no one's getting their records. That's what they've said. We're telling people we've got bipolar or we've been diagnosed with something, and then their medication is getting changed in the middle of it, or, I'm not sure, maybe you can correct me if I'm wrong, one of the other commissioners, but they're waiting months to see a counsellor or a psychologist. months. And some are being released before they even get to see anybody, which adds to the stress of being in prison on their mental health. So people are being untreated. And that's the case we've heard from the women.
They also made the point that they have to put in a form to ask to see a doctor, and that may take weeks before. So there is, even if they're feeling, and that we did hear from women that their medication from their strong diagnosis had been started, new medication stopped, started, and absolutely no continuation of care.
We know that there have been significant issues and failures with healthcare provision at the Davidson Trust Centre. We are aware of that and have been working hard to take interim steps ahead of the new provider starting from 1 July. So the government has funded us to move to public health provision. So Western Health will begin providing health services at Davidson Trust Centre in coming months, and underpinning that is a new health service model with significant service uplift for Aboriginal people. So that hasn't started yet, but it is imminent, and we think that this is going to change women's experience.
I hope it does change the women's experience, because one of the women, and this will stay with me, said to me that why did it take for someone to die for things to change when they already knew they weren't sufficient? They're the words of a woman incarcerated, and we are worried that we will be the next one because we're not getting the help we require. So I hope those words stay with you as you change, because they definitely will stay with us.
They will stay with me.
Can I also come back to the prison sitting idle? Where is it?
It's near Barwon Prison, so is that Lara? Is it near?
Whose country is that?
It's Watherong.
Watherong country. Yeah, 1 billion. Does it strike you as concerning that $1 billion is spent on a prison that is sitting idle?
I think, well, yes, but I think it would be more concerning to open the prison if you didn't need those beds. The decision was made at a time where the projections were suggesting we would need the beds.
Do you know what that kind of money, $1 billion, would do for our people?
It's an enormous amount of money.
It seems unfathomable to me that so much money has been spent on that facility with next to no outcomes or limited outcomes. While our Aboriginal organisations are fighting for scraps to try to make the services available to our people. $1 billion. It's a lot of money. Imagine what that $1 billion could do to Watterong as a traditional owner group. Sorry.
Thank you, Commissioner. Commissioners, I'm about to move from mental health to intellectual disability. If there's any other questions on mental health before I move on to that subject.
Well, I think we've only just scratched the surface, Counsel, and that's been useful. I think I just want to put on the record that I consider the system, the evidence establishes that the system is not acting to meet anywhere near the needs of people, and that the Aboriginal population of people incarcerated not having their mental health needs met, and who are the legacy themselves of colonisation, fills me with shame. And I would want to come back to this at some point.
I propose that that we will come back to the issue of dealing with mental health matters before we finish with these witnesses this afternoon. But it may be the case, Commissioners, that they need to be recalled at some stage.
Well, it's a huge multifaceted area. I'm in your hands, counsel, but I'm really saying it's...
Well, clearly the dimensions of this problem, which is quite significant, are many and varied, and they need detailed discussion, and the time that we have this afternoon is really
It's not adequate, no.
to explore the issues in the detail that's necessary. Commissioners, I'm aware that as a result of your visits to some centres, that there are matters of which you're aware that really you may want to ventilate with these witnesses. So I'm reluctant to move on, but there are a number of other issues that should be attempted to be covered this afternoon. So, with the promise to come back to it this afternoon, and we'll see what we can get through. So, in terms of intellectual disability, is there any assessment that's undertaken on intake of prisoners that assesses their intellectual disability status?
It's self-report, and we also check if they have, whether they have an intellectual disability flag, if they've been with us before. We used to have information sharing with DHHS. NDIS has probably changed the concept of, before it used to be intellectual disability in terms of the IQ measure. Now it's more about, I guess, functional impairment and what that means. But we do ask about, are you a registered intellectual disability? That's done at the beginning. The health assessment will also check for other disability needs and aids as well that people might need. Probably about 4 weeks in, we'll start to ask about, are you registered with the NDIS? Are you on the disability support pension is something we do ask upon reception. I'm sorry, I should have mentioned that before. So on reception, we'll ask about intellectual disability. We'll know if they've got a flag from DHHS. We'll also ask, are they in the disability support pension? 4 weeks in, we'll ask, do they have an NDIA package? We don't do the cognitive impairment assessment on reception. It's probably not a good time to do that. We do have a service, the Prison Disability Support Initiative, where we can refer, custodial or anyone can refer a person to for further assessment and support in terms of behavioural management support plans for people, as well as interface with the NDIA in terms of their packages, especially if they're transitioning out.
Thank you. You understand that many people in the Aboriginal community go undiagnosed with respect to their...
I would understand that, yes.
...impairment. So the self-reporting is only going to go so far in that knowledge.
Yeah, yes. I understand that, and that's where the Prison Disability Support Initiative does support, so where someone can be referred for further assessment.
Yeah, and how often is that facility exercised?
There are... the service is quite new. It's only a few years old. It's... had a lot of referrals. It's got more demand than that actual team can support at this point in time. The work that they do, I do know, is highly valued, but absolutely we have way more referrals than that team can support.
Clearly it's important to understand a prisoner's cognitive abilities in terms of how you provide for them in the first place, but what programs are available, how they might respond to commands and directions given by officers, whether they're being disruptive or that's simply a cognitive dysfunction. You'd agree that it would be important to know if you're responsible for the care of an inmate, to know whether they've got the cognitive ability to deal with the situation.
Yes, I do agree.
And in those circumstances where people are often undiagnosed, and we've heard from the Youth Justice team that I think the number was somewhere near 80% of children that present in that environment have some intellectual disability. There's no reason why we would expect the adult population to be too much different from that, is there?
It would certainly be much higher than the non-incarcerated population, maybe not as high as youth justice because there's a broader proportion of adults that end up in the adult system. But absolutely, I would expect high rates of cognitive impairment within the adult system.
That figure was in relation to Aboriginal young people, not the general population.
Okay.
Is the prevalence of such impairment something that your commission or the department is working on in terms of providing a better diagnosis and treatment for those prisoners?
Yes, it is the Prison Disability Support Initiative that is relatively new. I think it's only 2 years old. It's available at a lot of prisons. I'd have to check exactly which ones. It does allow for referral for someone to get an assessment. So exactly to your point about what is the diagnosis, but also importantly, how do you understand their behaviour in the context of their capacity? So behavioural support plans. And also the link to NDAA. It's fair to say that that pilot has shown the real value of it, and we need to, build up that evidence base of that need and the value it provides. There's unmet demand there, without a doubt.
Your answer just then you've given before. I realise that, but the comment that concerns me most, I suppose, is that there's unmet demand. How much unmet demand is there?
I could go and look at the referrals and I guess where we're at in terms of those assessments, and that would give you a sense of how able that service is to keep up with the referrals. That does go to someone has to refer as well, though normally there's a good indication, and so I think I could start to look at that in terms of giving you that information.
And who makes those referrals?
Anyone can make the referral. So the caseworker can make the referral, custodial officers can make the referral, anyone working in the prison system can make the referral.
So the custodial officers, though, aren't given any specific training in terms of identifying?
No, they can't do diagnosis, but they would be aware of someone's behaviour. And also one of the roles of that team is to actually do education about what to look for and when to refer as well. So
we've heard from evidence from the women saying that just to even get a doctor's appointment is difficult to get through one of the prison officers there. I don't see how a prison officer would be referring. I think the words were, we're at the mercy of the prison officers if they decide to put our forms through or not. And then we're waiting. Like you said, it was a pilot, so there's got to be some evaluation to the pilot.
It's fixed term funding. We did do an internal evaluation, not done by corrections, but done by our research and evaluation team within the Department of Justice to support continuation of the program, and we got funding for that. So we will absolutely need to build into that in evaluation to build a case for how that's been of value and what difference it's made.
It just seems that all the supports that are offered, or the getting a diagnosis or there seems to be a weight on everything. So, I mean, going back to Commissioner Lovett's point that there's a prison sitting there and you've got money going into that, yet these women need this now. Do you agree it's not, the programs are not funded correctly if we've got a huge wait?
Yes.
I think, yes, agree with that.
Yeah.
So just out of the pilot, what are the sort of early findings that you're
that having a behavioural support plan to go to counsel assistings, suggestion, does it really support the appropriate management of someone in custody and help officers understand how to work with that person for better outcomes for that person? That also the proactive link-in with the NDIA also does have a big impact in terms of, I guess, the NDIA package and the supports they would get on release through that program as well. They're the two key ones that I can remember.
And in your view, in your experience, by saying that, would it be something worth government investing in?
Yes, it would be.
Thank you.
If I understand your evidence correctly, the pilot program's not available in all facilities?
I don't think so, but I will have to double check.
I'm sorry if I've missed this. When does the pilot expire?
I think the funding is up for another, I think we've got about 3 years worth of funding.
As a pilot?
3 years worth of fixed term funding, and then we would have to go and make a case for more to continue it or expand it, depending on the evaluation and what that's suggested.
Is the high rate of the high prevalence of mental health issues and the likely high presence of intellectual impairment something about which the department consults with the Aboriginal community about options for servicing those particular prisoners?
I won't talk to the mental health. Certainly in the disability, in terms of the PDSI, I don't recall that being something that we have discussed through the Aboriginal Justice Forum structures.
And I think I would say the same for mental health. I'm trying to cast my mind back to whether that's been on any of the agendas recently, and I can't remember.
Mr. Phillips, I'd ask you either to keep your voice up or sit a little bit closer to the microphone.
Can't recall a time where that's been discussed with the Aboriginal Justice Caucus.
It's an issue that's clearly on the radar of corrections, though, isn't it?
Yes, it is.
And corrections you are able to raise issues of your own volition in the Aboriginal Justice Forum?
Absolutely, we are.
But you're not aware that it's an issue that either you or any of the Aboriginal agencies have raised in terms of provision of programs or services to the...
I'd probably say two things. One, I can't think of a time where we've had it as a substantive agenda item. I do know, though, that many stakeholders do raise concerns regularly about issues of well-being, the well-being of people in custody, and so that includes mental health issues, general health issues, well-being issues. So I can say, yes, we do hear regularly from our stakeholders that people are worried and that there are concerns about the well-being of people in our care. So that is it's often an individual-based discussion, but I can't think of a specific agenda item where we have consulted on a model for change with the Aboriginal Justice Caucus.
Do you think that it's a matter about which there could be useful discussion about systemic reform?
I think it would be very valuable and it's something that we can take forward.
Just as you gave evidence earlier about the... I'm moving to a different subject, I'm sorry. Just as you gave evidence before about the amendments to the Bail Act having impacts on the prisoner numbers and the predictions that you try to make to help manage those changes in populations, are changes to the Sentencing Act also something that has an effect on prisoner numbers?
Yes, that would be the case.
Sorry?
Yes, that would be the case.
And are you involved in review of the Sentencing Act, or have you been involved?
I haven't been.
So the reform to the Sentencing Act is led by my colleague Ms Chapman, who provided evidence yesterday. My policy team is involved in discussions with Ms Chapman's team. So certainly, yes, we are consulted by the lead policy area as a key input into the considerations, but ultimately are not responsible for the reforms.
In terms of the reform agenda overall, we've heard much in this commission about a self-determining justice system. The model of mass incarceration is one that is something the state of Victoria appears very wedded to. In terms of policy development, are alternatives, community-led alternatives, something that is on the department's radar?
I don't think I can answer that because I haven't been involved in the leadership of those reforms. I know that the Attorney-General, supported by Marion Chapman's area, is carefully considering what approach that could be taken to sentencing reform, so I know that work is happening, and I know that there will no doubt be keen to be consultation with the Aboriginal Justice Caucus. Now, I know that's not self-determination, and I'm not suggesting for a second that is. I probably can't comment any further on how that particular reform agenda is being developed, but I know it's under active consideration currently.
In the past, in other jurisdictions, there have been, for want of a better global term, bush camps used for sentencing of Aboriginal prisoners, where they spend time on country serving out sentences, sometimes under canvas or in rudimentary facilities. What sort of facilities, or does the Victorian government have any ability or commitment to that type of sentence option?
I certainly think it's a very interesting idea, and I'm aware that that's in place in other jurisdictions, and certainly something that warrants consideration about whether it's applicable to Victoria. So I can see no reason why that should be taken off the table. We know that innovative approaches to justice achieve very good outcomes, and I'm thinking about the Koori Court initiative in Victoria and the results that we've seen from that. Thinking also about therapeutic justice, the Neighbourhood Justice Centre. There are many examples where Victoria has been at the forefront, and not all of those initiatives are Aboriginal specific, but they're certainly examples of operational responses to sentencing and justice that lead to the right outcomes for very vulnerable people. I think in the same vein, that if that is an idea that is put forward by community and community feels that will achieve the right outcome for their people, then we should actively consider that.
And Commissioner Strong, that type of arrangement is not on its own something that your commission could not work with in terms of...
If you mean in terms of how managing a custodial sentence as opposed to a sentencing option, so how we manage people once they're sentenced, it is certainly something that could be considered. So within prisons, there's different types of prisons. And the idea being that you spend your time in the least restrictive option possible based on, I guess, an assessment of behaviour and risk. So we have minimum security prisons which don't have a wall. Where we do have a transition centre in the heart of Melbourne for people towards the end of their sentence, where they're going out on day permits and and just coming back at night time. So they're off looking for jobs and, getting their driver's licence and all that sort of thing towards the end of the sentence. So, a similar approach in terms of an on-country, that could be considered. I mean, you'd need to think of the parameters around at what point that applies and what criteria you might want, authorisation from government that they were happy with that risk, but yes, it could be considered. Yes.
So it's not something that you could immediately rule out as an option?
No, it's about, I guess, working out what that would look like with the relevant Aboriginal community and taking that proposal forward and getting that authorised.
And I take it that you would both accept that there might be great value for Aboriginal prisoners in being able to serve their custodial sentences in arrangements where they're on country or in suitable environments other than...
Yes.
Yes, I agree with that.
In terms of a self-determining justice system, how have you, Mr. Phillips, turned your mind to how that might operate in the corrections environment, and can you discuss that with the commissioners?
I can. I just, at the outset, am wary about providing an indication of what self-determination in the justice system could look like, as I know that it ultimately is a matter for Victoria's Aboriginal people to determine. But what I can say is that when you look around the world, there's a spectrum of different experiences in some parts of of America, looking at entire carved out parts of the system where First Nations people are responsible for the end-to-end management of justice matters relating to their people. Now that's certainly one end of the spectrum. We have under the banner of the Aboriginal Justice Agreement had some discussion with Aboriginal people in Victoria about whether there'd be an opportunity in the community correction space for Aboriginal-led service delivery. That discussion, I think, replicates some of the discussion that this Commission has had in the last week about Section 18 in the child protection context. And discussions with community have had a range of views, but what we took away from them was there is certainly concern about handing responsibility, what's perceived to be a broken or problematic system to First Nations people to then implement. So that is the feedback we've had about that. I do think there doesn't mean there's not an opportunity for Aboriginal people to take control of a community-based sentencing model. I just don't think we can assume that it should look like the community corrections model that we are currently operating. So it's a longer-term story about what is, and perhaps to your question, Mr. McAvoy, about sentencing options, different sentencing options. As part of that conversation, I think is where a model of self-determination could be delivered. There are a range of programs in the justice system currently that are delivered by Aboriginal people and Aboriginal organisations and are self-determined to that extent, but that is obviously within the broad framework of our existing kind of colonial corrections and justice system.
Can I ask just your position, substantive position? I know you're acting up at the moment. Is that position a member on the Justice Caucus? Is it a Justice Forum, continued member?
Yes, it is.
Okay, so you'd be quite well aware of the continued advocacy of the Justice Caucus around embedding more self-determination principles in the current model.
Yes.
Yep, thank you. I just want to be clear. Thank you.
Related to the question of self-determination in the correction system is the issue of systemic racism. The There was evidence given in another commission by Andrew Jacomos about how one might identify whether systemic and institutional racism exists within a government agency, and his observation in effect was when an overwhelming number of the people who are the subject of the system are Aboriginal people, but the people who are making the decisions at every step of the way about what happens to them and then have control over their lives and make decisions about them are non-Aboriginal people, then that's a pretty clear indication that there's some systemic racism at play. The Secretary yesterday accepted that the justice system perpetuates systemic racism. You accept that the manner in which the correction system operates perpetuates a form of systemic racism against Aboriginal people in Victoria?
Well, yes.
I think, and to my opening remarks, the colonial institutions that were created in Australia are the predecessors to the justice system that's in place today, and those colonial structures were based on were racist, and the structures continue today, and they continue to be racist, and we are doing. The obligation is on us to dismantle and change that. It's no easy task, but that is why so many. That's why we're doing the work, because we see the impact on people.
I suspect that commissioners know full well that government is a big machine that it's difficult to change the direction of, and that machine has for 230 odd years chewed up and spat out Aboriginal people. And part of its remit is to figure out how we change that machine so it stops doing that. You've come here and given evidence about some of the programs and things that are happening, but there's nothing in your evidence that tells me we're not going to be back here in the same position in another 10 years. Is there anything that you can say to the commissioners that would give them any confidence that we're not going to be having another commission in another 10 years' time asking why there's such a continuously high rate of overrepresentation of Aboriginal people?
I mean, I could sit here and talk to you all about all the small changes that we make with programs and reforming health services and the things we're trying to do to make the system better. And I know there are many Aboriginal and non-Aboriginal staff who are working tirelessly to do just that. But the chance for transformational change is through the government's commitment to truth-telling. The privilege to be here today to talk about what has happened before and what needs to change. I think that the government's commitment to reform, to self-determination and treaty, I'm not saying we're waiting, because we're not. We're doing everything we can right now, but that is what is different now, and certainly the Justice Department is deeply and wholly committed to the change that needs to take place, and the self-reflection about the source of shame for all of us about what our system does to Aboriginal people.
Can I just say that the word committed really rankles with me, because it's not a doing word. It's a word that sort of says we're taking it seriously, but it never says what action is going to follow on that. So I'm concerned that we're talking about being committed, not talking about what change is going to happen.
So certainly, I know our secretary talked about some of the immediate law reform changes that this government has committed to, and through bail reform, a change to the age of criminality. In the corrections space, a significant change to health service provision, moving to public health provision, particularly for women in the first instance, is a significant change. We are certainly working to implement change on the ground on a daily basis. I mean, that's why people come to work every day.
How many deaths, Aboriginal deaths in custody, have there been in Victoria?
Since the Royal Commission in 1991, in the adult custodial system, 23.
How many people have been accountable for those 23? How many? Zero? Zero accountability?
I can only say that I sit here before you today to tell you what I can, and to, on behalf of the department, express accountability for the department's failings.
Yeah, and I appreciate that in a sense, but zero accountability in a sense, and we're talking about confidence about not sitting here in another 10 years' time. It's really concerning. Zero accountability, and we sit here, and as our counsel said, we've seen non-Aboriginal people continue to maintain the power and authority over our people, and I guarantee that people working in the system are also continually being promoted who could have done something about some of those deaths, and they continue to be promoted in the system today. I just want to make that statement.
Thank you, Commissioner. Part of the operations of corrections within the justice portfolio extends to post-release programs. That's correct?
Yes.
In your view, is there unmet demand for access to post-release support?
Yes, I would say that's true.
Perhaps a polite way of saying, could you do with more resources?
Yes. I mean, any service system will say that, but yes, we could.
Do you also provide pre-release programs?
We do. So I guess we call it transition programs, and some of them are pre-release and they're pre-release preparation. Some of them span the transition from pre into post-release.
One of the most telling pieces of evidence that this commission heard was from its very first witness, Uncle Jack Charles, who has since passed. And he spoke of a cycle of being released from prison into a state of homelessness that happened over many decades on that cycle. That's something that still occurs for many prisoners today, doesn't it?
Yes, housing is a real issue post-release, yes.
And the post-release program resources that the Commission has is insufficient to meet that demand from inmates?
That would be correct. So we tend to support, fund NGOs to provide post-release, so pre-release planning, the idea that their worker comes in and builds a rapport with the person getting out of prison, works with them on what they want and what their goals are in terms of when they get out, puts in place a plan. That will often involve picking them up on the day of release and taking them to where they're going to be staying and then working with them. Often that's about some emotional and practical support, but also service navigation of managing your way through, how do you access housing, how do you access components. We do have a limited number of houses that we have direct placement control over, for want of a better word. It's only 80 transitional houses. Maribyrnong Community Residential Facility, which is a relatively new transition facility, has about 40. So we are then, I guess, trying to get access into the housing service system.
But housing in Victoria is under great stress at the moment.
Absolutely it is, yes.
And so finding additional houses is not easy, and I understand that even if you could find some additional houses, there's going to be resourcing issues that limit your ability to meet all the demand.
Finding safe, sustainable housing for people getting out of prison is probably one of the biggest challenges, whether that's public housing, transitional housing, private rental. There is it's very difficult.
But you accept that that meeting that housing need is a very critical
Yes, I think it's basic, yes.
aspect of ensuring that people don't reoffend.
I absolutely accept that. I think it's a basic human need, and it's also important for reoffending as well.
I would call it a basic human right, but I'm really wanting to share with you a story. On the very day that Uncle Jack Charles gave evidence about this, I was standing with him outside Charcoal Lane, and a young man was walking along, an Aboriginal person, and they recognised each other. Uncle Jack had not seen him for a while, and he said, "Where had you been?" And the young man said, "I'd been in prison, I've just done some time." And he said, Uncle Jack said to him, "You're looking pretty okay, where are you off to?" And the young man, who had been released that day, said, "I do not know." And Uncle Jack said, "Well, what about tonight? Where will you be staying?" And the young man said, "I do not know." Uncle Jack, being Uncle Jack, said, "If you just go down the road, turn right, knock on that door, then they'll put you up for the night, a relative." That's how bad the system is.
Sadly, I agree, that does not surprise me.
I want to turn now to the provision of health care. It's a difficult subject about which we've heard much evidence in this commission. There have been complaints from many witnesses to the effect that the delivery of health care generally, we're not talking mental health now, is insufficient to meet the needs of the Aboriginal community. Is the provision of health care to Aboriginal people in Victorian prisons something that's currently under consideration for some improved service?
Yes, it is.
Can you tell the commissioners what consideration is being undertaken?
I can. So the model of healthcare in prisons in Victoria in recent years has been private service delivery. There was a primary health contract in place. There is a primary health contract in place that comes to its conclusion at the end of June this year. So the department has been working for a number of years to re-tender that contract. As part of that process, a key area of focus has been improving Aboriginal healthcare across the system, and there is now a new model of healthcare that's attached to the contract that will come into effect from the start of July. Some of the features of the new contract that are worth mentioning are that there is a new Aboriginal health check that will be undertaken for all Aboriginal prisoners. That is equivalent to the health check that is available under Medicare. Now, the Commission may already be aware that prisoners are not eligible for Medicare, and this is a matter of some advocacy by the Victorian government with the Commonwealth over some time that has not yet been resolved. But in the interim, under the new contract, a Medicare equivalent health check will now be available for Aboriginal people in prisons. So that is new. The second new feature is that an integrated care plan will now be available for all Aboriginal people. So that seeks to look at both health and social and emotional wellbeing, and where consent is given, connect a person's family in with the care, the health and wellbeing care of people in custody. That plan will also enable consideration of the needs of Aboriginal people when they are released from custody. So there are two key new features that are provided for in a new quality framework that's attached to our contract. There are a range of other service uplifts that are provided for in the contract. These range from improving access to an Aboriginal health workforce. So the providers are required to have a particular proportion, from memory it's 5% Aboriginal workforce, and will be providing scholarships to help develop an Aboriginal workforce who then can provide services in prison. So these are examples of key features that are embedded in the new contract, and they will apply across the men's system. The big shift I mentioned earlier is that in the women's system, additional funding has been provided by government that has enabled us to move to a model whereby health services into Dame Phyllis Frost are provided by Western Health, and services into Tarrangower prison, which is the minimum security prison near Castlemaine, are provided by Delkaya Health, which is the local health provider. I'll just make one other comment, is that there is a requirement that all of the health providers engage with the community-controlled health sector. The details of that are still being worked out, but I can say that Western Health will be partnering with VARS, the Victorian Aboriginal Health Service.
Sorry, is your microphone on?
It's green.
It's green. Am I still?
Okay. No, we just get it. You just wanted to check it. That's what I was...
Try again. Maybe that was the problem. Thank you. I thought I was trying to talk loud. Yes, so the different health providers are... lost my train of thought now.
Talking about VARS.
Yes, thank you.
VARS and Western Health.
So VARS and Western Health have a relationship, and we'll be working to improve Aboriginal-led care in custody. We are exploring whether ultimately there's a model whereby there could be direct Aboriginal health service delivery within our prisons, and that's something the Aboriginal Justice Caucus is very interested in. We've met with the ACT correctional system. They have an Aboriginal-led model of healthcare in their prisons. Now they have a very, very small prison footprint, so there are different complexities, but there is an example in Australia of where that model is working well, and it's something that we're interested in exploring, subject to the service model and funding.
So this service model, can I just ask, how is it monitored, and what are the consequences for care providers if these targets, I presume you've got targets and you've got measures that you're going to be matching them again, are not met?
Yes, so that's the role of Justice Health. Justice Health, so the business unit in the department, is responsible for managing the contracts. So that'll be the contract with GEO Healthcare for the men's system, and then the two public providers for the women's. So there's a clinical team in Justice Health who is responsible for clinical oversight, and we have an Aboriginal health team that's been established in Justice Health in the last 6 months that's led by a senior Aboriginal woman who's very experienced, and she's been building the team under her. They will support and provide a leadership role in overseeing the contracts. So there's contract management, and then there's also auditing. So I think it's fair to say that There's been some room for improvement with the quality of the services that have been provided by Justice Health. We know that, and the team is working to rebuild that function to be able to make sure the new service providers are on track.
You accountable for Justice Health?
I am.
Yeah, I knew the answer, but I wanted you to say it.
Yes, I am. Yeah.
And thank you for the answer, but it still doesn't tell me what the consequences are if these are not being met from the service providers, which I understand is one of them is still a private provider.
Yeah. So it's commercial consequences under the contract. I can get you the specific penalties, but it's yeah.
What if someone dies in custody for a health-related issue? What's the consequences then? Because it's a lot for our community.
So there are if there are failings on the part of the health provider, and we know that in a number of the recent passings, healthcare provision is at issue. So there are contractual consequences or for breach of the quality of care that's expected, but it's and Larissa, I might throw to you to talk about in our private prison contracts. There are different types of consequences for failure that are much stronger than our health contracts. So I think when there is a failure by a private prison, so if there's a passing in custody in a private prison that's attributable to a private prison staff member, there are a range of serious financial consequences, and
it's more consequences for our community than it is financial, and these are people's lives, and we really need to remember that, because you've got these key features of a new fancy health system, but it needs to meet the needs of our people.
There's different levels of accountability in the context of someone passing around public and private. Is that what you're saying?
I'm saying that the contractual mechanisms. So in the public system, if there's a failure of a staff member, of one of the correctional staff members, the consequences are that there's a disciplinary process for staff, but there's no commercial penalty for Corrections Victoria. If there's a passing in one of our private prisons and there's a breach, it's identified that there's been a breach by the prison operator, then there are commercial penalties for that prison operator.
If I understand it correctly, there's a new contract which has been entered into, which will commence operation on 1 July with GEO.
That's correct.
And the term of the contract, are you able to?
It's 5 years.
5 years. And I don't know if you're at liberty to give this evidence, but does the government have the capacity to vary that contract so as to engage directly with an Aboriginal community health provider to deliver services to Aboriginal prisoners?
Yes, we could do that.
And are you aware that in the Northern Territory there's an Aboriginal organisation called Danila Dilba which provides primary health care to the youth detention facilities?
Not specifically aware of the Northern Territory example. I have been in discussions with the ACT, but not the Northern Territory.
So it's from the department's perspective, it's not certainly there's no contractual impediment to the department entering into some alternative arrangement with respect to Aboriginal prisoners for primary health.
The existing contract with GEO contemplates a role for Aboriginal service delivery. It doesn't go as far as the model in some other jurisdictions, so I think there would need to be some negotiations with the provider to make sure we could have that work under the existing contract. But certainly we see a lot of potential in the idea of direct service delivery by Aboriginal health organisations.
Well, you're aware that the whole reason for the existence of Aboriginal community-controlled health services is that Aboriginal people tend to go and have their problems seen to by an Aboriginal controlled organisation and tend not to go to mainstream health services. You're aware of that?
Yes, we're aware of that.
And so in a closed environment like a prison, if somebody's not inclined to speak to the doctor who's not from the medical service, their health needs might go unmet. You accept that?
We do accept that.
It would seem that there is a good case for engaging directly with the Aboriginal community health services.
Yes, and we have been having some discussions through VACCHO, who has helped build a relationship between us and direct service delivery community-controlled health organisations in Victoria to progress that conversation. There were, most recently the discussions occurred towards the end of last year. But I know, at the most recent Aboriginal Justice Caucus meeting, the desire for us to progress this as a priority was raised, and we've committed to taking that conversation forward.
Yet you still signed this new contract for 5 years.
Yes, we have. There is. Yes, it was at the end of a tender process that ran for multiple years. I think that there was the ability to make a decision to adopt a different approach for the women's system. The timing, worked for us to be able to do that. There was certainly discussion about the men's system and what the options would be for public service provision there. The feedback from our colleagues at the Department of Health was that in a post-COVID environment, the pressures on the public prison system the pressures on the public hospital system meant that they couldn't cope with the demand pressures from the correctional settings, and we were told that wouldn't be supported by health at this time.
Counsel, if I may, you'll be familiar, with Mr. Phillips, with the coroner's findings in relation to the tragic death of Veronica Nelson.
Yes, I am.
And you'll be familiar with the fact that the coroner held the state very much to human rights account across many human rights fronts for that death. And the answer is yes, it'll need to be.
Yes, I am.
Thank you. And that's because Ms. Nelson was in state care at Dame Phyllis Frost Prison. Again, yes. You'll need
yes,
to
I'm
say
aware.
Yes.
Yes,
the nod is not picked up.
Yes, I'm sorry.
I'm just wanting to know what is the position with respect to private prisons? Is it accepted or not? Has it been considered or not? Whether the Charter applies to a prison that is privately operated.
That is
My understanding is that it does.
Yes.
It does, because it's providing public services.
Yes.
So there would be no difference whether to be a death in custody in a private prison to the human rights accountability
That's correct.
that might arise through the coronial process. Thank you.
Can you say, Mr. Phillips, whether the contractual arrangements specify compliance with the human rights obligations of the state in terms of delivery of those healthcare services?
I don't know specifically. I know the legal position is that it does by operation of the human rights legislation, but whether that's embodied in our contracts, I couldn't say, and I can take that on notice unless Larissa.
So, in terms of observation and performance, is the contract performance monitored by anybody to ensure that those human rights obligations are being performed?
I'll hand that one to Larissa. The oversight functions in relation to private prison management sit within Corrections Victoria.
So in relation to private prisons, so the Human Rights Charter does apply. Most contracts do refer to needing to be compliant with state legislation, and of course the Charter of Human Rights and Responsibilities is state legislation. The answer is yes. I mean, it tends to how we monitor private prisons is it's often compliance against Commissioner's requirements, which do have charter assessments against them. So, yes.
And what are the consequences of breach?
It depends, I think, on the issue, it can go from being issued a request to a contractual improvement plan to termination of the actual contract. The other thing I would probably mention, because I think it's relevant, is that obviously the work cover legislation does apply to all prison operators and to health staff and healthcare providers in prisons as well. I think that's also relevant in this context.
Thank you. Chair, I have about, on my estimate, there's maybe 15 minutes of additional questions for these witnesses.
For me.
I've checked with my learned friend, Mr. Knowles. It doesn't seem to be any issue from the state's perspective. I might ask whether the witnesses are able to stay on for a short period longer. They're indicating yes.
Yes, we're all in agreement. Yes. Thank you.
Thank you, Chair. The topic that I want to take you to now is, although it's related to the mental health issue that we touched upon earlier, it's a sensitive topic, and that's one of self-harm by prisoners. We know that it's a serious issue. We know that it's prevalent from other evidence. Do you have figures of reporting on self-harm by Aboriginal prisoners?
We do have those figures. It is something that we report to the Aboriginal Justice Forum when we have a forum, so regularly. I do not have them on me.
Something that you can provide to
It
the
is,
Commission?
absolutely.
You accept that it's a serious issue
Yes, I do.
and that it's something that is prevalent?
I would need to go back and check, I guess, what's understood by prevalent. I accept it's an absolutely serious issue and any self-harm's no good. We have a combination of people who might self-harm, but it's and it can be very serious, maybe even catastrophic. But then we also have some people that chronically self-harm, which is also really concerning as well. And we try to provide that information that allows people to analyse that as well and understand it. It's a very serious issue.
So Corrections has a strategy for managing prisoners that self-harm?
Yes, we do. We have an at-risk framework, yes.
And that framework was the subject of consultation or discussion with the Aboriginal Justice Forum, or not?
It's been such an established process. So ever since I've been working in the system, the at-risk framework has been around, and that is really around if you're aware or you have concerns about someone's risk of self-harm or suicide, you trigger a referral. The referral is to a mental health professional for assessment, and that must be done within 2 hours, and that's a 100% requirement. Based on the mental health assessment that's done by the mental health professional, people will get a rating of risk, and then there will be a joint discussion with both custodial health staff and other staff within the prison system on the management plan to mitigate that risk. That has been around so long that I couldn't go back to how that was evolved.
At what stage are Aboriginal community organisations or an individual's family brought into that risk management strategy, if it's an Aboriginal person?
So if it's an Aboriginal person, the Aboriginal Wellbeing Officer will be engaged. We do not do family engagement well in the adult system. That is something we need to change.
But, well, from your answer, I suspect that you understand that the importance of being able to communicate with family at times of stress for Aboriginal people?
Yes.
And so does the responsibility for ensuring that happens fall to the wellbeing officer?
It would be something that's discussed at the joint risk review meeting, which has a number of different staffing groups, from health to custodial to, it might be our clinical team and the Aboriginal Wellbeing Officer, in terms of the plan around that person and if that, how to facilitate that, when that would happen. That would be something that would be discussed and individualised.
I cut short the discussion in relation to mental health earlier. It may not be something, Commissioners, that we can adequately deal with now, but if any Commissioner has questions of the witness that they would like to ask before we rise this afternoon, that perhaps that could be done now.
Yeah, just on your last subject about including family, we've heard from plenty of women who are mums that don't have access to see their children. Half the time they don't know where their children are. And then we heard in one group, one woman tell another woman how to get access to her children, or how to get a phone call or a Skype, or surely they get told this information of how to do these things.
I guess you've heard that, so maybe not always. I would certainly hope so. Zoom visits they should be easy to arrange. We also do have family engagement workers at Dame Phyllis Frost Centre and at Tarrangow, which is the other women's prison, whose part of their role is to support proactively the engagement with the family and children.
We're not here. That is not what we're hearing.
Well,
and the men as well are not. Spoke to several men who their children were on permanent care orders. So whilst they're in custody, they're never going to see their kids again because they're now on permanent care orders, and we've had to refer them on to people that can help them, lawyers that can help them, because no one's giving them access in the prison system. We've heard horrific stories about women not even being able to access sanitary pads. That's degrading.
I agree.
It just shouldn't happen. Explain it, like a sanitary pad.
There's no explanation for that. If that's happened, there's no explanation for that.
Crying out for mental health facilities, putting in form after form, not wanting to complain and not wanting to upset any prison guard because they know that their form won't get to. You have a dentist that works, once a week? Half of those women have teeth issues. I don't know if you've had a toothache for quite a number of months, some of them, and some of them don't get the things that you're talking about because they're on remand and they don't have access to it. Or by the time they leave, their number hasn't come up. It's a bit of a lottery. Just because you've committed a crime doesn't mean they take away a person's human rights and dignity, let alone dying in custody. Also, and I will add, because I promised one woman, I'd bring up the fact that it's costing her, for a young woman who entered the system because of crimes of poverty to feed her family was her original charges, gets minimal, the amount they get paid in there for the amount of work, yet I don't know if you've got landlines, but if you ring a landline, it's quite cheap. But if you ring a telephone, you get 12 minutes and it costs you, they have to, that's contact and connection to family, kin.
Per call.
It's
at $12 per call, I think.
Call a mobile is what, just to clarify, we're calling a mobile. So landlines is a cheaper rate. It still is expensive, but if a person wants to call a mobile, it's at the same rate as probably the early 90s.
I am really aware of that issue. It reflects a contract that we have with the person that provides a company that provides the phone system, because it is the telephony involved in that phone system, because there's an ability to record and there's only certain numbers that you can call. And the scale, you're right, it hasn't kept pace with the fact that people don't have landlines anymore. People have mobiles, and in the community now, you can get a plan that's really quite affordable. The Zoom visits are free.
They're not getting them. Like, let's be clear, they are not getting them, or they have to wait months to get them. The rate people are charged for things in prison, sorry to cut you off, but I just need you to know, some of them can't even afford, you know, shoes, and they don't want to be wearing the prison issue shoes because, you know, and we've got people borrowing other people's shoes to look decent to come and see us as commissioners, which was really sad. They can't buy what they need because the rate of getting paid for the work they're doing, you know, one said, oh, we sit there all day and we screw a bolt on an end. And I said, and then what happens to them? No, they probably take them over the men's and they unscrew them. Right? I just needed to make those points. These are human rights to be able to contact your family, get visits, see your kids.
I agree, and thank you. I will absolutely look into the Zoom, and I'm happy to come back to the Commission with more
And the
information.
rate of those phone calls.
I do know the rate of the phone call. It's a harder one to
It
unpack.
needs to be looked at for every person in a prison system. You know, that calms them and keeps them feeling safe and comfortable because they know what's going on outside.
Yes.
So why would that not be a priority? These are fixable things.
And a big part of our culture is family and connection to family. It's not about really touching a possum skin. It's more than that. It's deeper than that. Thank you.
Commissioners, that concludes the questions that I have for these witnesses today. I indicate that counsel assisting may request that the witnesses be recalled at a later hearing block, particularly to deal with some of the issues that we haven't quite examined to their fullest today.
Can I just jump in? One of those, sorry, just before you finish, one of those things for me is the cultural review into corrections. We haven't even talked about that at all today. That is a significant piece of work. How many recommendations?
86.
86. How many have been accepted or committed to?
So the government released when they released the report, they released the government's response. I think it was on 24th of March.
Yep.
There are a number of recommendations that they did agree to commit to straight away. There are other ones that the commitment is to work through an implementation strategy along with stakeholders. Because there are so many, and you're right, it's a very important report, it's very far-ranging. We really do need to do some thinking through about what do you do first, what do you do in what order, what is an interdependency, how would you go about something, so something like cultural awareness training, and how do we absolutely lift that and make that mandatory in terms of refresher trainings and all along your career, and what does that training in terms of the competencies and the understanding need to instill. So, working that through with our Aboriginal Justice Forum structures to then go through about, appropriate procurement to then work through how we actually roll out the training. So some commitments have been made, but others require more thinking work about what do we do this year, what do we do year two, what do we do within our existing resources, what do we won't be able to do within existing resources and need to build a case, and how do we engage with Aboriginal community, but also people in custody and also our workforce.
I think we'll have, coming back before us in the future, I think we'll have more to ask about that.
We certainly
We're eagerly monitoring, I guess, any progress on that report.
Commissioner, can I just ask you to confirm what I think is the case, that neither you nor the government disputes the findings made in the report?
That's correct.
Yes. Thank you.
Thank you, Commissioners. I think I may have raised with the witnesses earlier their willingness or ability to come back to this commission at a later stage. I ask that they be released now. There is a housekeeping matter that I need to attend to before we rise this afternoon.
A short break in the meantime. Do you mean that we might have to come back, or you're...
No, I'm ready. I'm ready to proceed.
Yes, very well.
Chair, you should have before you a tender list for partial tender list for this hearing block. There's a
I have it now.
the tender list for documents 2.2.1 to 2.2.8 for today, the 3rd of May 2023, and accompanying that tender list, the Chair, is a proposed interim restricted publication order pursuant to Section 26 of the Inquiries Act 2014. That order that covers each of the 8 documents in the tender list, and the order in relation to the orders in relation to those documents are that, subject to paragraph 2 of this order, an interim non-publication order is made in respect of the following documents given to the Yoorrook Justice Commission by the State of Victoria, including contents thereof. Each of the documents is listed. And then Order 2, this interim non-publication order will expire upon the publication by Yoorrook, meaning Yoorrook Justice Commission, on its website of each of the documents listed in subparagraph 1. And there is the note 1, pursuant to Section 48(1) of the Inquiries Act 2014, Victoria, it is an indictable offence for any person, including a body corporate, to knowingly or recklessly contravene an order of a commissioner under Section 26(1). I ask you, Chair, to make the orders in terms of the interim restricted publication order before you in relation to documents 2.21 to 2.28.
Make those orders as sought.
Thank you, Chair. I'm sorry for my absence. I can indicate the state supports those orders being made.
Thank you.
Thank you, Chair. That was the only matter of housekeeping from me. The Commission is not sitting tomorrow. The next witness will be the Attorney-General on Friday morning, the 5th of May, 2023.
Brought forward to 9 a.m, I think.
Brought forward to 9 a.m, yes. Yes, Commissioner Bell, thank you.
Okay. Thank you. We will adjourn and resume on Friday at 9 a.m. Thank you. Thank you. Thank you.